Let's see how this goes, you guys. I just came because Critical and Rico couldn't make it, and I didn't know if anybody else was coming. Excuse me, how are you?
Okay.
Oh, we can't go in yet? Can we go in?
Hit the switch.
Okay. Okay. Thank you. Hey. Excuse me.
Oh, really? Oh, I haven't seen that before. What about this? That never works. Oh, it never works? Okay. I could run and get a stand.
I'm gonna see if I can put my camera. I'm gonna see. Hey, Amethyst, how are you? Good to see you. Okay, hold on, y'all. Let me see if I can do this right. Okay, I'm gonna see if I can move my camera over to behind everybody. Y'all let me know how you can hear. I'm gonna bring everything up here.
Whatever works, right? No worries. That worked out better for me too.
I have my mic, so I'm gonna try to hook it up, y'all. Bear with me, I'm gonna try to hook it up, you guys.
you want, position that wherever you like.
I was trying to do the microphone, you guys. I'm not sure if it's doing it, so I'm just gonna move closer. Trying to hook up the microphone, you guys. I'm trying, but I don't think it's gonna work. Let me know if you can hear okay. Let me see if I can. Give me one more second. Wait. Can you guys let me know if you can hear okay? I'm trying to hook up the microphone. Okay, that's it. It's it. Thank you. My oh my God, you the best. Let's try to. Oh. Critical. How do I hook this up? How do I hook this up, Critical? Yeah, I'm not. Yeah, I'm not. I'm not able to hook up the microphone, you guys. I tried. I'm gonna wait. I'm gonna just wait to learn how to do it, you guys. Carol is definitely giving fashion today, y'all. Her sweater is so cute. I should just sit up there with everybody else. Everybody else sitting over there. I should just go over there.
Scooch over more. Okay, so are we good then? All right. It's done. I'll turn it on.
Yes.
Do y'all prefer this view or me to just sit in the audience? Do you like getting the whole room
Okay,
view?
we're reconvening the Township of Thornton Electoral Board. I'm Ellen Raymond, the chair.
Thank you. I will go ahead and conduct the roll call. Chair Ellen Raymond.
Yes.
Member Al Swanson. And Member Lynn Osfeld.
Present.
Okay, all board members are here, and let the record reflect that the meeting is being convened at 1:30 p.m. We do apologize for the delay. There were some technical difficulties. The first thing I would ask is, and I apologize for not getting this on the agenda. I know that at the last hearing, there was a request made by Attorney Kraftheffer due to her schedule to see if her case, the case that she is on with Attorney Mullen, could be taken first, and that's the second case. I was supposed to put that on the agenda. I did not. I put it out of order, so I do apologize for that. So I think at this time it would be appropriate for the board to make a motion to consider case number 25 TOEB Soup 02C first, and to take that item out of order. Second? Okay, I've got a motion made by Member Swanson and a second by Chair Raymond. All in favor? Okay, motion carries. So we will now call case number 25 TOEB Soup 02C. Attorney Kraftheffer, can you hear us? You're muted.
I can hear you. I can't hear the electoral board members.
Okay. Okay, we can hear you. This is going to be an interesting hearing, just because of the technical difficulties that we're having. So I just ask everyone to bear with us. Okay, so there was a motion to strike and dismiss filed in this case, and so I think that the first thing for the board to do would be appropriate to hear the arguments related to the motion to strike and dismiss. Does the board want to put any restrictions on the arguments, or how much time do the candidates think that they're going to need for each side of their argument? Or the parties, I'm sorry, I didn't mean to say the candidates, the parties.
I don't think we would need more than 15 minutes.
Okay, 15 minutes?
Could we limit that to 10? I just want to say,
Sure.
we have thoroughly read, and I'm speaking for myself, if the board can tell me if they agree, the objections, and we had quite a bit of time to thoroughly read the motion to dismiss, unlike some of the pleadings that I received this morning. And both were very thorough and well written. So if it's possible to just not read what you already wrote and just hit on the highlights, and to keep it to 10 minutes, and then let us ask questions of what we are wondering about after reading it, that would be very helpful.
I have no problem. I was not planning to read word for word from my submission.
Okay, and Member Osfeld, are you good with a 10-minute limit for oral argument for both sides?
I'm fine with that. I just like to have for the record an outline of the points that the people raise, so that they don't read everything, but they do state for the record what the basic points are that they're arguing.
Okay, so you're asking them to just give a sort of summary.
A summary overview, yeah.
Sure. I think that they both probably intended on doing that.
Yeah. I could do that relatively quickly.
Okay, Mr. Mullen, you're good with this as well?
I am, thank you.
Okay, Ms. Crafthopper?
This.
Ms. Crafthopper, you good with that as well? You can just give me a thumbs up if you want. You're muted.
Yes, that's fine. Electoral board members will.
I don't know what she said.
Yeah, we're having a lot of trouble understanding through this feed. Possibly. Okay, well, we'll figure, well, I guess let me ask this. Will Mr. Mullen, are you going to be handling the argument primarily?
I will handle the argument primarily, yes.
Okay.
And
And
are
then,
you able, is Teresa
I-
able
we'll-
to text
we'll-
you or?
We'll try to do it by text.
Thank you.
okay. And then for the board members, Ms. Crafthopper has put on the screen that she's only able to hear me. So I think it's possibly your microphones might be off. So if you are going to speak, just so that Ms. Crafthopper can hear what's going on as well, just turn your microphone off and then you can, or on, and then you can turn it off to avoid feedback issues. So, thank you, everybody. All right, so then I guess we should get started. Mr. Ladizinski, is
Yeah.
there a motion?
I will start off, the first point is that the objectors filed a verified petition. And their verification does not say anywhere upon information believed. It says we have personal knowledge of all these facts and these allegations. In their response, the true nature of this objection comes out. And it's a quote, "This is the worst kept secret in Thornton Township." If we want to go by gossip and innuendo, we will be here, literally, for days and weeks. If they had personal knowledge and facts, those should have been pled. This is no different than when someone files a mortgage foreclosure or some other verified pleading seeking this type of relief to remove a candidate. But they chose not to. And the reason why they chose not to is because they don't have a case. And this even becomes clearer. Point 2. They changed their objection. The objection now is my client never lived at the Harvey residence. That's not pled anywhere. How is my client supposed to mount a defense if the objectors are going to make these shifting arguments? I cite the Maskin case, and they want to talk, it's all about proof. They're wrong. Maskin talks about what must be proved, but what must be pled. They have never pled in this case that this is an abandonment case. So what documents do I have to gather for this case? They don't. They don't point out that, are they saying that this 30-day rule about residency under the township, you have to live in the precinct and be registered and live there for 30 days before, are they going to be counting the time that my client who's in Springfield is down? They've not provided any information. I cited the Daniel case, and the reason why I cited Daniel versus Daly, and they want to talk about, well, that was kind of a shotgun objection because it dealt with signatures. This is no different than a shotgun objection. You're not a resident. We're gonna shift the burden to you, Mr. Senator Harris, to show that you're actually a resident. The burden's on you. We've provided you with enough information. One of the best known facts is Senator Harris owns a Beggar's Pizza and several other Beggar's Pizza. One of them is in Harvey. His Harvey residence is right by his restaurant. There's an article, we provided an article where he's actually worked at the restaurant. So, okay, yeah, that's where he works and he has a residence there, nearby. What do they cite? They cite, we have personal knowledge. My third point. Before we go any further, and under this board's rules, if these three objectors have all this personal knowledge, because it is the worst kept secret in Thornton Township, they need to testify as to what their personal knowledge is. You don't get to sign a verified complaint and then say, well, no, that's not fair. We don't have to do anything. Well, yeah, you do. Under the rules of this board, under the Daniel decision, they have to. That becomes very, very, very important. My last point, and this goes to why this should be dismissed. You've already had a taste of two of the objectors with regard to the one objection as to whether or not there was a full objection filed to Mr. Harris. I also cite the Muldrow decision, where that electoral board sat at the city of Markham City Hall till 1:15 in the morning, in which Mr. Price instructed a witness to leave. What this is going to turn into a game, and when someone alleges that someone doesn't live there, okay? Simple checking of public records that we provided you all the petition sheets, provided, in response to their subpoena, like, listen, they're asking for mortgages. There's no mortgage on this Flossmoor property that Senator Harris happens to own. There's no homestead exemptions on there. What they're going to say is, well, you need to put that on in your case. No, they have the burden. They have not pled sufficiently a residency case, because the purpose of this, to fully state your objection, is to allow the candidate an opportunity to, what do I bring in and defend? Based on their response, they want Senator Harris to bring in literally 15 years of documents to establish his residency. That is not what the law is. They have a deficiency in their pleading, and for those reasons, this objection should be dismissed.
Thank you. Mr. Mullen, would you like to respond?
Absolutely, thank you. We're at the pleading stage. This is a standard residency objection with standard residency objection allegations. These are similar to the residency challenge that have been filed by both counsel on the other side. I've been doing this for a long time. I have never seen in a case an allegation that there was not physical presence, or there was not an intent to remain, or there was abandonment. The allegation is simply, there is a 1-year residency requirement and a 30-day requirement in the precinct to be a registered voter, and that was not satisfied because the candidate said that he lived in Harvey, which is in Thornton Township, when in fact he lives in Flossmoor, which is in Ridge Township. And that is the allegation, and we are required at the evidentiary hearing to bring forth evidence to prove that. But this is the pleading stage. And we have gone beyond what is required at the pleading stage by including exhibits in our petition. And those exhibits included the homeowner tax bill showing that Mr. Harris owns the property in Flossmoor. He filed with the State Board of Elections paperwork over many, many years saying that his residence is in Flossmoor. And the form that he signed to say where his residence was under oath. So we have provided a great deal of information to back up and show the good faith of the allegations that Mr. Harris is not a resident of Harvey or Thornton Township. That is not required. What is required is an allegation to state what our objection is. And our objection is simply, he is not a resident of Thornton Township and does not meet the residency requirement in the Township Code. And second, that he is not a registered voter because he has not lived in the precinct for 30 days. and therefore he is not qualified under the township code. And when he signed his statement of candidacy saying that he was a resident in Harvey, in Thornton Township, he was not being truthful, and therefore the statement of candidacy includes a falsity and is invalid. That is the allegation, and we have to prove that allegation. We understand that. But no matter how much documentation Mr. Ladizinski comes in with to try to get rid of this case at the pleading stage, this is just the pleading stage, and we have alleged everything we are required to allege. There are a lot of cases that have been cited here, but what you don't see is a single case dismissing a residency objection on the grounds that physical presence, intent to remain, or abandonment has not been pled. Not one. In all of that. With respect to the objectors, there are two cases that are relevant to the objector's role in this process. One of those is the Daniel case, which Mrs. Ladizinski litigated and cited. The other is the Nader case. The Nader case dealt with a request for a subpoena on the objectors. And what the Nader case says was that is outside the scope of the board's duty, that you are not to look at what the objectors did and put the objectors' petition together. The only question before the board is the candidate a resident of Thornton Township or not? Now, if Mr. Ladizinski believes that the candidates have personal knowledge, and they did verify, and that is correct, then he can call them as witnesses and ask them what their personal knowledge is in the evidentiary hearing. But he cannot subpoena them under the Nader case to ask them how they put the objection together. Now, when you look at the shotgun cases, what they do is they look at the documentation that was filed, and they say, this is shotgun because every signature was objected to. And you look at the documentation, and from its face, you see that it's a shotgun objection. You don't have someone come in and do testimony on whether or not it's a shotgun objection. You look at the paperwork and you say, does this appear to be a shotgun objection? If you're sure it is, then you get rid of it. If you're not sure it is, then you do a 10% records check and see whether it's good or not, right? You don't call in people to testify, well, I went down to the board and I looked at these signatures. That's not how the process works, and that's what the Nader case says. So we're happy to have our clients testify as to what they know, because they know a lot, and they did a lot of work on it. But it's not a question of whether the petition has been pled properly. It's a question of our burden of production and our burden of proof at the evidentiary hearing. So for purposes of pleading, this is an allegation that has been adequately pled and adequately supported to show that it's in good faith. So the motion to dismiss should be denied.
In reply, Nader's a different case. Nader was not a verified petition. Your rules address this issue. I've handled plenty of cases where there's allegations of shotgun objection and people have testified. Senator Ricky Hendon had to testify at a hearing as to whether or not the petitions were, the objection was put together. This is not a case where I want to know the motivation. Is we have people that have signed a verification, this is true and correct. And so they attach a document. Well, this is an article from the Lansing newspaper, okay? Something off the internet, that's great, I can find that. But it really comes true when you look at the response. The response says this is the worst kept secret. So this is gossip and innuendo. This is no different than the birther theory involving President Obama, and courts ruled, you want to make this objection, he doesn't have to come forward with this birth certificate. This is just nonsense. What do you have? What evidence? If you're going to make this allegation a verified petition, what do you have at the time you signed that verification? Not what you did afterwards, what you did now. They cite to the State Board of Elections website page they did it. That's his mailing address. That's a mailing address, not his residence address. We are going to be faced here, and this is the burden that they have. They have to plead and prove. What are they pleading and proving? What are they pleading? What do I have to defend on behalf of the candidate? Because if you look at their response, they say he never lived there. So I have to go back and get 14 years of records? They're trying to amend their objection. They want this to be very fluid, and I'll call it loosey-goosey. You must fully state your objection for the purposes of the candidate's due process rights and what I have to bring in to rebut. As I sit here today, I do not know what they're really alleging because they did not sufficiently allege the following, okay? Like in Mascom was a detailed petition that had detailed facts of points in time, events. There was actually a resident that moved into that residence that was cited. The lease was cited. The voter registration of that new resident was cited. There's nothing here other than, like I said, gossip and innuendo. These cases cannot be brought this way. This board should not be forced to sit here for hours and hours and hours for someone to engage in malicious mischief. That's what I'll call it. If you had all this facts, all these personal knowledge, he doesn't live there for the following reasons, that should be in the objector's petition, the verified petition, because that would be the basis for their objection, setting forth what I need to defend.
Okay, so are both parties done?
Yes.
Okay, thank you. So now it's time for the board to begin its deliberations. So I would ask the board to, I guess, just start discussing this and give your thoughts. Looks like Member Swanson, looks like you've got some thoughts you wanna?
Mr. Ladizinski, as to your question, the statement of having to go back 14 or however many years. The law only says residency for a year, and to be a voter 30 days in the precinct. Why do you have to go back 14 years? The only relevant time period is just the 1 year.
Their response says he's never lived there. So their response is going to be, he never lived there, so I'm going to have to go back in time and start when he started his physical presence there.
But all that's relevant is 1 year.
But it's clear what they plan to do because they're saying he never lived there. So now, how do I, because they're going to point to, oh, he lives in Flossmoor, okay? He lives in Flossmoor. I have to go out and get witnesses now from Flossmoor that no, he has not been there for X years. That is what my concern here is, if when you read their pleading, and I understand when they have to plead for 1 year, but that's not what they're doing with their response to the motion.
Do any of the board members have any questions of the candidates council or objectors council?
Do you want a motion before we discuss, or there's something to discuss?
Sure. Yeah, that's generally appropriate. I mean, sometimes with these electoral board hearings, we don't always follow Robert's rules to the letter just because they're a little bit more informal, but
How do you want a motion first before we discuss?
I like that idea, yes.
Yeah, I'll put a motion on the record that the motion to strike and dismiss case 25 TOEB sub 02C be denied.
Second,
just write this down. Okay, so we have a motion by Member Swanson to deny the motion to strike and dismiss, and we have a second by Chair Raymond. I will call the roll. Well, I'm sorry, first you guys, do you want to have discussion? You said you wanted to have discussion, let's have the discussion.
I would just like to point out a couple things. One, I agree with my fellow electoral board member and the attorney Mullen for the objector that the candidate's attorney maybe is going on a little bit of a stretch when he says he has to prove more than the 1 year prior to the 30 days, just because of some wording in a reply or response. So I don't agree with that. Yes, if your candidate lived there this year, show us that he did. I definitely don't agree that it's a shotgun allegation.
If I may interject, the burden's not us to show that he lives there. The burden's on them.
Okay?
They're shifting the
Either
burden.
way,
See, this is what my concern
Well,
is, they're
that's-
shifting the burden to us.
it does end up, usually like the Rahm Emanuel case, they proved the wedding gown was there. Show me a wedding gown. Anyway, I don't agree at all that it's a shotgun objection. To me, it's the complete opposite. This is one narrow area of law, whether he's a resident or not. It is not challenging 5,000 out of 5,001 signatures. So I don't agree with that argument. You cite the case of Jeffers, which refers to one meager sentence. I don't agree that this objection raised one meager sentence. I may agree with you in a different case before us, but I don't in this one. I think they added details that made me curious, like the vacant issue of the water bill. I think they gave details more than just a mere allegation of residency. So those were just a couple points I wanted to bring up.
Okay, thank you. One thing I did want to actually point out to the board, because there's a lot of talk about this 30-day thing as it relates to section 5/5-2. I just want to make sure that the board is aware of what that section actually deals with. That section deals with registering to vote. That section states, and I'm going to read it into the record for everyone's benefit. No person shall be entitled to be registered in and from any precinct unless such person shall, by the date of the election next following, have resided in the state within the precinct 30 days and be otherwise qualified to vote at the election, at such election. Every applicant who shall be 18 years of age or over on the day of the next election shall be permitted to register if otherwise qualified to constitute residents under this Article 5, Article 3 is control. So just wanted to make sure that the board is aware that that section, it's not per se a residency section, and it doesn't per se require somebody to, I guess, be a resident 30 days prior to the election. It actually is a section that deals with being a resident 30 days prior to registering to vote. So I just wanted to make sure that the board was aware of what that section says. At least that's my read of it.
Thank you.
Okay, Member Osfeld, is there anything that you wanted to add?
Basically, I think this is a factual situation, and that I would go along with the motion to deny the motion. I would go along with the motion to deny the motion to strike and dismiss, because I think it's a factual issue, and it only goes to meeting the requirements to be a candidate. It doesn't go to anything else. We don't want to hear 30 different witnesses, and, you know, it's hard to prove a negative, I understand that, but this has to be a fast track. It's not your normal procedure, and so we just need to move to the basic evidence.
I believe that Member Swanson wants to offer some more statements.
Well, I agree to some extent with Mr. Ladizinski that the objection could have been worded with more specificity. However, this is the pleading stage. I believe there is enough there to withstand the motion to strike and dismiss. Whether there's enough there that can be brought in and prove it at trial is another issue, but that's not what is before us at this time.
Okay, so then at this time, is the board done with its deliberations as it relates to the motion to strike and dismiss? Okay, so then we'll go ahead and call the roll. So just for the edification of the public, we are now voting on the motion, which was made by Member Swanson and seconded by Chair Raymond, to deny the motion to strike and dismiss filed by the candidate Napoleon Harris. I will now take the roll. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Osfeld?
Yes.
Okay, so the motion to strike and dismiss has been denied. The next order of business is to move over to the subpoenas. And the subpoena requests, as the burden on this case is on the objector, not the candidate, it would be my suggestion to discuss the subpoenas presented by objectors first, and then move over to the subpoenas requested by the candidates. Do the parties agree with that order of presentation?
That's fine.
And could I ask of the objector if there's any way to limit the subpoenas? Could you tell us that now?
Well, I think that first we should hear from both parties as to what their arguments are really quickly, and then I think that the board should discuss what limitations, if the parties are willing to self-limit, then that's great. If they're not, then obviously the board needs to make a decision as to what sort of limitations it wants to put on the subpoenas.
After an initial presentation from the parties, I envision after looking at the subpoenas and the requests, we're going to have to deal with them individually, one by one.
I believe so. Okay, so Mr. Mullen, do you want to go over your request for subpoenas?
Thank you. As we just discussed, the question next Friday is going to be whether or not there is sufficient evidence to show that the candidate does not live at his residence. And so, in addition to the documents that are publicly available, and we have issued FOIAs, we have done public record searches and things of that nature, there are individuals who are unwilling to give us information, whether that be testimony or documents, and we, as a result, sought to compel those by subpoena. And so there are basically three categories of subpoenas that we ask for. The first is the candidate and his wife. And this asks for them to both appear and testify at the hearing as to the facts regarding their residence. And second, to provide materials that would presume to have their address on it. So their bank statement, their cell phone bill, their water bill, their gas bill, things like that. And those are pretty standard requests of a candidate and the candidate's wife. In fact, I used Mr. Ladizinski's subpoena on my candidate in a case a couple weeks ago as the model for what I used to draft the rider for the candidate here. And so we're not asking here for personal information, like we're not asking who the beneficiary is of their life insurance. We're not, and we've put on all of the subpoenas a redaction notice saying, redact the confidential personal information. All we want is the information relating to the address of the candidate, in some instances, the candidate's wife or the candidate's family. And these are fairly standard requests with respect to the candidate for documents in their possession that indicate where they and their family live. The second set of requests are subpoenas with outriders, and those are subpoenas on a number of individuals who reside in Harvey, nearby the address the candidate says he lives, and a number of individuals who reside in Flossmoor, near the address that we allege the candidate lives at. One of the individuals we've asked for is actually in a townhouse adjoining the building that is listed as the candidate's address in Harvey. And while these individuals may be willing to talk, there are a lot of reasons why they're not willing to talk or they're not willing to appear. But these are the people who will have personal knowledge of where Mr. Harris spends his time, because they're the people in closest proximity to the two addresses that are alleged to be his residence by the candidate and alleged to be his residence by the objector. The third group of requests are subpoenas ducus tecum to entities. So the Village of Flossmoor, the Park District, the Library Board, the Illinois Secretary of State. And these are for what the candidate uses as his address on his official documents. And it is entirely common to get the address of the Secretary of State, what the driver's license is, where the vehicles are registered, and things of that nature. That is a extremely common subpoena. Mr. Seckler filed in another case in December and received all that information from the Secretary of State. So again, finding out what address the candidate uses on official documentation is relevant. And those are essentially the three buckets. With respect to some of the objections, we understand that this is a lot of subpoenas, but that doesn't put a burden on anyone except for us, right? We have to serve them, we have to get the documents. It doesn't matter to the Village of Flossmoor whether we've also sent a subpoena to the Park District. It doesn't matter to the Park District whether we've also sent a subpoena to the library, right? They only have to answer their own subpoena. So we also know that we are back here in 5 days, and we're not going to be able to serve all of these. We're not going to be able to get a response to all of these. So while it may seem like a lot, what we're doing is making sure that we're going to get enough to prove our case from what we send out. And again, these subpoenas are seeking address information. They're not seeking financial information. They're not seeking personal information, etc. And the only other thing I would say about the subpoenas is, this candidate has been accused in multiple occasions publicly of not living where he says he lives, and this has been something that's been going on for a long time. So we expect that the candidate has done work to cover his tracks, and that it may be more challenging to prove that he doesn't live where he says he lives. And so we believe that we've got to cast a wide net, but none of this is unusual, none of this is unreasonable. These are standard subpoenas. I've been a litigator for almost 30 years. I've sent out hundreds and hundreds and hundreds of subpoenas, and I've always been able to work out with a person subpoenaed how to respond to them, right? We've never had motions to quash or motions to compel, because you work it out. You know what you want, and you can work it out with the person that's being subpoenaed. And I don't think there's anything oppressive about any of the individual subpoenas that ask the library district, what address did the candidate and his family use to get their library cards? That's not an oppressive request. To ask the Park District, do they have a park card? To ask the village, do they have a car sticker? And what address did they use to get their car sticker? Those are simple subpoenas for basic information about where the candidate lives. And so we think, as a general matter, they should be granted. If there are concerns about individual ones being overbroad, or individual ones having other issues, we're more than happy to make this reasonable for everyone involved. We've got 7 days to do this. We're not, we're not trying to break everyone's backs. We're trying to get as much as we can in a short period of time. So we ask that those subpoenas be granted.
Thank you. I did have a really quick question, Mr. Mullen, just something that you had said related to the subpoenas to the various public entities. I was just curious, I know you guys said that you filed some FOIAs and stuff like that. Did you happen to FOIA those public entities yet? The library, the Park District, or anything, to get any of that information? And if so, what was the result of those FOIAs?
Right, so as we put in the motion, one thing that they can delete the address from the FOIA response. So we can't get, so there's some things we can get from the FOIA, but like if we FOIA the city for whether he has a parking sticker, they're gonna redact
Right,
address.
but they would still have some sort of record that, at least that responsive record might exist. So again, I'm just
Right.
wondering.
I know that we have filed FOIAs. That's a question honestly for Ms. Kraftheffer because her firm has been doing the FOIAs. I have not. So if you want to ask her, but I do know that a number of them have been done and we're not trying to be duplicative of things that have already been requested.
Okay, I was just trying to, see if there was a way to narrow the scope. Does the board want me to ask Ms. Kraftheffer? All right, hopefully we can hear you well. So the question was basically that, what sort of FOIAs, who did you guys FOIA so far? I guess the public entities, and what have you received?
So, we have seen some entities have provided it, but we have not yet seen the entities that have provided it.
Yeah, Carolyn, the connection is poor. Let me ask, is there a way to turn it up without causing a bunch of feedback?
Can everybody in my room mute your microphones?
Yeah, let's try that. But we're gonna all mute our microphones and we'll see if that works. Give me 1 second. Okay, let's try now. Try now. Okay, so they requested information from some entities and subpoenas to us.
Sorry, we requested information.
She wrote, we requested information from some entities and the subpoenas do not include, and then it sort of cut out. There was a little comment bubble on the bottom. I don't know, I've never used this software.
So I'll give you one example. So actually, I turned this off. So we did FOIA for his paycheck information from his job as state senator, and so we have the stuff that is addressed to Flossmoor from the state of Illinois.
Okay.
So that's an example, and we're not trying to get things that we can't get, but the stuff that we are asking for, I don't believe we can get elsewhere.
Okay, I was more trying to figure out sort of what has been filed so far and what is still pending.
And I can add to that, I filed some FOIA requests, FAMA, with Angela, and I worked with Carrie Lynn, for example, the Village of Flossmoor, the State Board of Elections, but also I can add in drafting other FOIA requests, just generally responding to them. As previously been said by Mr. Mullen, is if you go searching for documents from a certain address, the address can be redacted, so
Absolutely.
it will be useless. And if we do say the names, like we want information just on this name at this address, the information we could get could be so worthless that we would effectively be going on a fishing expedition. We want to avoid that. We want to give you proper documents with proper names and proper address.
Okay, understood. I just was trying to clarify what has been done so far. Okay, I have no further questions of Mr. Mullen, and I think Mr. Ladizinski was gonna reply. I did want to read really quickly into the record the comment that Ms. Kraftheffer had said. She said, we have requested information from some entities and the subpoenas do not include the entities that have responded with the addresses. Otherwise, it is an exemption under FOIA. The public bodies do not have to provide residential addresses. So, okay, so we're ready for you, Mr. Ladizinski.
Okay. We have spent a lot of time going through each one of these subpoena writers and these subpoenas. My concern is one of what Mr. Mullen said. We send a subpoena out and someone sends them all the bank information. Oh, I'm a lawyer, don't worry about it. I'll protect your private information. I know how banks, I got a subpoena, we're gonna produce records. It doesn't just limit to the information about address. Sending a subpoena to the Illinois Department of Revenue for someone's tax filings, okay, what does that have to do with residency? Okay? You want the address? These subpoenas are overbroad, and it's not your duty as a board to redraft these. Let's talk about the subpoena request to my client and his wife. Communications regarding children and their schools, any mortgages you have. My client owns several businesses. What do those have to do with this? Do they limit that subpoena to either Flossmoor or Harvey? No, they do not. We've identified all these issues like insurance policies, medical insurance, life insurance. Really? This is, and I can hear Mr. Price going there. Yeah, this is a game because guess what? There's no protective order here, and when this stuff gets out there in the public, and believe it or not, there are actually election lawyers that have filed people's social security numbers and dates of birth in public records. And if I was a voter in Cook County, that's what I really feel proud that I know that lawyers are going to get this, because once this records exist, this record gets filed in the Circuit Court of Cook County. And we can talk about redactions, all right? Oh yeah, these documents are going to come to council in the form a financial institution produces it to them, all right? And I'm not saying Mr. Mullen's not going to redact it, but now I have a lawyer, an opponent. And let's be clear here, they represent an opponent in this race, Chris Clark. All right? There's no protective order in place here, other than Scout's honor. As a lawyer, I'm not going to do it. So when you look at, and let's start with my client and his wife, and look at how there's no restrictions on some of these documents limited to the 2 addresses. There are none. Especially with the issue of the mortgages and other documents. I've already talked to you about, IRS, the Illinois Department of Revenue. My client's going to give you, he's going to, don't get his driver's license, so not going to be happy with the address.
Madam Chair, I would suggest that the objector subpoena the candidate to produce a limited number of documents, and the candidate can redact what is not essential to cut out, because there are just way too many people. You're talking about testimony for multiple days, and it gets to an issue of what are the documents that prove that he does reside where he states to reside, and let the attorneys work together to work on the documents that will be submitted, as opposed to, I'm sympathetic to not, to, A, there's time factor, B, things slip up, so that even if the objector redacts everything, you shouldn't have to go through that. But the attorneys working together to produce the documents should be sufficient.
So if I understand correctly, because there was a couple things that I heard, from what you were saying, Member Asfeld. You're requesting that the candidate and objector that the objector gets the documents, sends them over to the candidate, then the candidate does the redactions?
No, that they work together, that the candidate produce the documents and they can redact as they feel appropriate. The candidate shouldn't have to show the objector his tax returns, but there should be a way of working out a system so that the address of the different documents can be produced and verified and nothing else.
So you're saying rather than having a subpoena issued to the candidates, you're sort of saying more so of a request to produce?
Yeah. But it's a subpoena to the candidate to produce these documents, and they can go into a closed room and make sure that everything's redacted, however they want to do it. But for us to go through each and every document and listen to all the testimony is very time consuming for something that has to have a fast turnaround.
Oh, I tend to agree that this is obviously a very large scope with a lot of documents that are being requested. Member Swanson?
This is a very large scope that's being requested, and that's why I suggested earlier, we need to go through each of these riders individually, and I think we can very simply eliminate categories. And I'm looking at the rider to candidate Harris. Okay, for A, state has his driver's license and state ID card. Okay, copy of that, that shows an address. Lease agreements, is any and all? No. Within the last 2 years for the address I'm giving as court. Any and all records, that's way too broad. Just, what rent payments he's made within the last year, if any. Insurance policies, that's not gonna prove where he lives. That has nothing to do with residency. Utility bills, that doesn't show that he necessarily lives at any one place. So that should be, D should be stricken, in my view. Or E should be stricken. Insurance policies don't show residency. Would not allow D. Utility bills doesn't show residency. His name may be on because he may pay the account on the house on Flossmoor while he lives in Hardy. So his name may be on there, it doesn't prove residency at all. For G, pay stubs indicate they've already got that information, so it doesn't need to be included in the subpoena. Leases related to the house on Dunfrey Street. I don't know if he leases that house or if there's a lease for his showing that he rents that property on Dumfries from somebody else. Okay, a lease effective within the last 12 months. Mortgage statements don't prove a thing about residency, in my view, so that should be, I think, deleted. Bank statements, same thing. J should be, is too broad. It's not show residency. And same thing for K. Tax bills, we've already got that in the record. Some of it has been there, but they don't show residency. You may have an arrangement for whatever reason property tax bill has his name on it, but it doesn't necessarily prove he lives there. Same thing for the ungiveness court in Harvey. Property tax bill would go to the owner. If he rents the place, he wouldn't show up on that, so that doesn't show residency at all. Credit card statements, they don't show residency. That N should be deleted, in my view. Same thing for, on loan statements. And P on those bills. And Q the same way. R, the same view, they don't show residency. Vehicle registrations don't necessarily show residency. I don't see the validity in that one. Tax returns, maybe the last year's tax return only limited to showing the front of that where it shows the address, perhaps. Gym card, library card, park district card, I don't think that shows residency at all. So I would go through these other subpoenas in the same way. There's a very limited amount of things to Mr. Harris that I think are relevant to a lot. Mr. Mullen, you want to respond?
Yes, I think you are correct that none of these.
The chair wants to add something really quick.
First, I think.
Here, speak in the microphone.
I think the only disagreement I would have with my fellow board member is S is in Sam. I think vehicles are supposed to be registered to our home address, so that I would like to see, and it's probably easy to obtain.
Okay, so none of these things individually shows residence, but what they do is, if the water bill, the cell phone, the automobile statement, all of these things are mailed to the Flossmoor address, they make it more likely than not that he is residing there. And all of these documents have address information of the candidate. So if the candidate comes in here and says, I live in Harvey, but we show that the water bill, the gas bill, the cell phone bill, the bank statement, his tax return, all of those things have a Flossmoor address on it, then those are used to challenge his testimony that he lives at Harvey. And while any one of those individual things doesn't mean that he lives there, it does indicate that it is more likely that he lives in Flossmoor if all of these documents that he's giving to official organizations and to get mail that he has to pay bills from, if he is having all of that in the Flossmoor address, then that challenges his testimony that he resides in Harvey. So I don't care how many phone calls he made, I don't care who he made phone calls to. The only question is, where is his cell phone address? Where is his cell phone bill addressed to? Where is his bank statement addressed to? And the address that he uses on all of this official document, I believe, is relevant to where he resides, because he's going to put his residence address on these documents to make sure that he gets the things he needs to get in the mail, and he's telling people that this is where he lives.
And for the record, Ms. Krafthofer also made some comments. She stated utility bills show usage of utilities, which would definitely show residency if there's no electricity or water being used for the property, etc. She also stated that municipalities require residents to have vehicle stickers. Those go to residency. Park districts have resident and non-resident fees, as do libraries, and those go to residency. If he has a resident fee in Flossmoor Park District, then he is claiming residency there. And then I was going to ask Ms. Krafthofer, it might just be easier for me to try and call her. So I'm going to just try and call her right now and see if that works a little bit better than this. So I'm going to put her on speaker.
To just the addresses on these documents, but if the candidate that he doesn't have park district, we would have no way to prove that he did, just based on his representation. So, as Mr. Mullen mentioned, the whole burden on getting all of these out and getting all of these documents back in time is on us. We have to prove this. And with respect to the witnesses that we've requested, we don't know if we're going to be able to serve them. We don't know if they're going to be on vacation. You know, so we might seek a subpoena for 8 witnesses and be able to serve 2. This isn't going to days and days of testimony, even if we're able to have everybody served and respond. It's a very narrow scope of inquiry. Thank you.
Okay, did any of the board members have any questions?
I just wanted to clarify, I think it was misquoted, because she said a quote from Ms. Raymond, but the only quote I said was to add back in S. I may want to add back in other paragraphs, but I'm not sure where the quote is coming from, maybe a different board member.
And just for the record, that was actually a member Oswald that had stated that.
If I may chime in here,
Yes.
it is 2025. Everything's online. Okay? I have to tell you, if I was in a residency challenge, I would be in deep trouble because I live in my office. My vehicle registration for my personal cars come to my office. I live in a high-rise condo. I'm lucky if I see mail once every 2 weeks. My credit card bills are online. They have an address on them from 7 years ago, somewhere I lived 7 years ago. I don't believe there's much probative value considering everything's online. My bigger concern here is a subpoena gets issued. They comply with the subpoena after the hearing. And in that trove of documents from Chase Bank that they received are all the financial institutions, my client's business records, all this stuff. There's no protective order here. Listen, Scout's honor, I'm sorry, it doesn't apply here. These subpoenas are seeking information that no person would ever want to give up, and no court would allow it to be given up unless there was an issue involving a partnership or there an accounting action. These subpoenas, the clerks that get them at JP Morgan Chase, produce the account statements, here you go, because that's what they're going to take. All accounts, all documents showing his address on it. Oh, go ahead, it's what it says is redact account numbers. It doesn't say redact transactions. That's what my concern is here. We can't control third parties and how they produce it. And I'm serious about this. When I have a conversation with another lawyer during a hearing, you know you produce social security numbers and dates of birth? It's a public record. All right? I don't represent those individual voters whose private information has been produced out there. This is a campaign, all right? If you think Scouts Honors applies in campaigns, I don't think we just forgot what just went on with Trump Biden. Okay, that's what my concern here is that, and when everyone needs to be candid here, I put it in my submissions. Ms. Kiercrafter represents Christopher Clark, who's running for the same position here. So this is not just giving some other lawyer. We are giving the opposition that may get documents that are personal in nature. And that is my biggest concern. And these are so overbroad, and for that reason alone, we could tailor these down. But I don't think these should be issued. If they want to go chase witnesses, go chase witnesses. You know, you want to get the neighbors next door, I'm totally fine with that. But when you start sending subpoenas to third parties, okay, one thing they didn't point out, concealed carry permit, your FOIA card, it's not discoverable, okay? This is called the Second Amendment. Illinois' been sued on this issue. So asking for that type of information, and what relevance does it have? Because those are 10-year cards. My card has an address on it from 7 years ago. Have I updated my information with the state? Yeah. Have they updated it? No. I mean, so we're going to be in this mini proof period of, well, why didn't you change your address? Aha, we got you. That's what my concern is.
Madam Chairman, council's points are well taken. I was thinking about the fact that things can be sent to a different address than where they resided. But for things that would be indicative of where he does reside, could we do an in-camera inspection? Would that have any problem? Violet, just to look at the documents so that they are presented, they are held, that we don't do anything other than to say, here's the address. Would that solve it? I don't want to go through a lot of documents that are not going to be dispositive. You know, at the same time, it should be fairly simple to determine where somebody resides.
I understand where you're going, and while I agree, I don't know that this board actually has the authority under the election code to do something like an in-camera inspection. And the reason I say that is because, the reason I say that is because this board is bound by the Open Meetings Act. And I don't know that, I'm not aware of any closed session exception that we could invoke to go into, say, a closed session to do an in-camera type inspection. And candidly, I work with the Meeting Act, the Open Meetings Act on a fairly regular basis, and I'm not aware of anything.
We agree.
So I appreciate the idea, the creative thought of, you know, how can we streamline this and figure things out. I just don't think that this board has the authority to go into a closed session type situation to do an in-camera inspection of the documents.
So objector, I thought Carrie Lynn made a very good argument to put back in paragraph F. Can you possibly self-limit and suggest paragraphs that you would strike that Judge Swanson brought up? I don't think we need to see.
You're talking about the subpoena on the candidate?
Yes. Yes, in the paragraph F with the electric and sewer bills for Harvey. I don't know why font one would be relevant to Harvey would be. And then could you suggest possibly striking more personal information that really probably is sent online and not indicative of address where it's sent, for bank statements, credit cards, and other personal information such as those? Are there paragraphs through you that you would suggest striking at this point?
That I would suggest striking?
Are you leaving it yourself at our
Carrie,
mercy?
saying something. Okay, I'm sorry, say that again, Carrie Lynn. Oh, hold on. Okay, try that again. I went to my Bluetooth, I apologize. Try it now.
Point out.
Okay, hold on. So she says, hold on one second, sorry, still experiencing some technical issues. Can you repeat that? You said something about limiting it to 1 year?
Yes, we can certainly limit to 1 year.
But
But
it
because
is
the one's there, he can go through the individual requests and pare them down so they're more narrowly limited to addresses. But you know, interestingly, what Mr. Ladizinski is arguing is actually that it's their fear of a subpoenaed party producing too much information. And we'll be sensitive to that. I mean, we would agree to a protective order in that instance, and we don't plan to wait around private information in a public setting. We're also subject to ethics codes here. I mean, so to the extent that we will agree to a protective order not to provide that, that's certainly reasonable. It's just a residency case.
So unfortunately, this board does not have the authority to enter protective orders because the statute doesn't provide it.
I was actually just going to say the same thing. I don't, you know, we have subpoena power under the statute, but I don't believe that this board likewise has the authority to enter any sort of protective orders. If anything, if the board is inclined to issue any subpoenas related to the bank accounts or anything like that, what I would suggest is a severe limitation on the scope of it and literally just basically subpoena saying, send us a document with the address, like send us, yeah, the front page of the bank statement would, and that would, I think, be it.
I would agree with that. The problem is dealing with Chase Bank. The subpoena, most of it for the Midwest is in Indianapolis. I sent a subpoena in a case, limited it, and they produced way too much in a case, and it's just like, but there was a protective order in that. I had to advise the other side, return the documents. I should have never received these documents. That's what my concern is. And if this occurs after this hearing's over and the board has adjourned, which has been my experience, I get some responses to subpoenas after a hearing, and now I have documents floating out there. And like I said, you know, we're all attorneys here. And I'm not trying to disparage anyone. I just have too much experience in this arena, is when the political opposition gets something and it gets out there, and then we have to deal with it, and usually it's disastrous.
Okay, could, just to answer the chair's question, if that's okay, you asked me what I would delete. If I could flip that question and say what I would think is most important.
Yes, that would be very helpful.
I think the vehicle registration.
Can you say the paragraph letter?
Paragraph S. I think when you file your tax return, you are saying that that's where you live, so the address on the tax return, nothing else. That's paragraph T. Paragraph.
For 1 year, is that 1 year?
For 1 year's tax return.
There, and just, Attorney Otten just pointed out to me that in the subpoena writer, it does state that these documents would be for November 1st, 2023 forward. That's what you have in your subpoena. So
Correct.
I know there was some discussion about going back years, but it does say November 21st, or November 1st, 2023 forward. So it's basically a 1.5, almost 2 year period.
Well, it's 1 year from the statement of candidacy.
Exactly.
Well, 1 year and a month, but okay.
It would be more complete if it also had an end date with that, if we're going to go along with that. No documents after November 1st, 2024. It's only in that 12 months. Put an end date on it if you're going to do that.
We could do that, yes.
Because, currently it says to the present.
Yeah, I believe paragraphs O and P, which are for cable, I'm sorry, that's P and Q, which are for the cable and internet service at the address.
Why is P relevant?
Why does it show where he lives?
Because if he's getting cable at the Flossmoor address and not getting cable at the Harvey address, it's more likely that he lives in Flossmoor.
At the risk of being accused of arguing a point for Mr. Ladizinski, which I don't intend to do because I want to get this limited down to what's relevant. How, if he has an agreement with his family that he will pay the bill for that, whether he lives there or not, how does that prove he lived there?
And I would also just offer that I tend to agree. I mean, my dad lives in Jonesboro, Illinois, and I pay his internet, I pay his cable.
But it would show that there was service being used in Jonesboro. There's no internet service in Harvey, is that
Correct.
correct?
Correct.
That's what I want to know.
Well,
And maybe he has a phone and he does it, and it's not absolute proof, but it'd be interesting.
Right.
I'm not interested whether Flossmoor has it though.
Right, and then the utility bills E and F.
And again, I'm not interested in Flossmoor, I'm only interested in Harvey.
Harvey would be good.
So ease out, agree? You're saying you
Yes.
agree? Okay.
Yes, and then for D, well, we'll skip D. I think A, B, and C, the driver's license, if he has a lease agreement in Harvey, and any receipts for payment of rent in Harvey would, I think we all agreed, you all agreed with that was relevant.
A, B, and C were left in
Right.
by member Swanson.
but these other bills don't show vote proving residency. He may have some agreement and he's gonna be responsible for it and pay it, but it doesn't show that he lives there. And I don't think it goes to getting information that would be even under Rule 201 of the Supreme Court, leading to information that might potentially be relevant. I don't think it even meets that threshold.
But some of these items like, is it F? They're looking for not for the address of the usage. So if you have a 0 electric bill, you may not work.
Even if the electric or sewer bill, utility bill shows usage, if the family lives there and he's responsible for it, even though he doesn't live there, what does it prove? It doesn't prove he lives there.
The one at Harvey would prove that there's no usage.
I think their argument is it's vacant, that family members live there.
I'm actually talking about Flossmoor address.
No, I'm not looking at anything for plus.
Okay, so for the record, I think to streamline this, is the board in agreement that it does not want any subpoenas issued, or it wants to at least limit the scope solely to the Harvey property, not the Flossmoor property? Is that what the board is desiring? Okay, so then I think that, let's just kind of go through this really quickly. Let's eliminate those.
And that holds, in my view, holds for all of these riders and not just the one we've been discussing.
Right.
I think we could summarize the paragraphs he limited to, which were A, B, C, F. And correct me if I'm wrong. From F, do we go to, well, can you recite the paragraphs in a row of what you're leaving in, and then we can vote on those paragraphs?
Okay, so A, B, C, F.
Not P, but Q. Q, S.
Well, let's let Ed make his, or Mr. Mullen make his statement.
Q, S, and then T.
So A, B, C, F, Q, S, and T? And U, if everyone says. So A, B, C, F, Q, S, T, and U is what the objectors are agreeing to limit the scope of their subpoena for.
Would
And
you
then
be,
T would just be we'll add the November 1, November, when was the statement? Statement of candidacy was filed
In December?
December 6th to 16th, so we'll say it ends on December 16th, and for T, we just want the page with the address.
So November 1 to December 16th? November 1, 2023 to December 16, 2024. Okay. So again, just for the record, what Mr. Mullen and Mr. Krafthofer are proposing is to limit the subpoena to Napoleon Harris to include items A, B, C, F, Q, S, T, and U, and to further limit it to the dates of November 1st, 2023 to December 16th, 2024. How does the board
can we
feel
ask
about?
the candidate's response to that?
Sure. Sure, Mr. Ladizinski, Mr. Sackler, and Ms. Centeno, do you have any response to that?
So with regard to tax returns don't have to be to your residence. I do them for clients, they go to their businesses for their personal returns. And once again, all that is filed online. It's no longer through the U.S. Postal Service. With regard to these other ones, you're going to rule the time period's fine as far as the limiting the time period.
So you're in agreement with the objector to all of his subpoenas?
I wouldn't say he's in agreement.
No, we didn't, no agreement.
you're going to issue a subpoena, authorize the issuance of a subpoena that's going to be modified, that's going to just have A, B, C, F, Q, S, T, and U. My biggest concern is on the tax returns are, you know, I don't know if my client's under an extension, so there would be no page number. There would be no, you know, you just file the electronic extension under the social security numbers.
And realistically, would we get a response by next week from the
Well,
IRS?
well, let's keep in mind, this is not a subpoena to the IRS. This one is a subpoena to the candidates.
Oh,
So these are documents in the candidate's possession or the candidate's control.
so he'll ensure we didn't get that. Okay.
Right, well, if he has it, I think is what Mr. Ladizinski's saying, is if he has it. Yeah, he may have filed an extension, maybe he didn't, who knows? And I guess I would just say, as it relates to, you know, Mr. Ladizinski, Mr. Sekla, Ms. Centeno, as it relates to any sort of privacy concerns, what I personally have done in the past, when I've been representing candidates that were objected to, is I literally redacted every single thing on there except for the address. And I used the computer programming redaction, so you can't hold it up to a light and see through it or anything like that.
I make sure I complete that process.
Okay, so is the board in agreement to issue the subpoena for Napoleon Harris for items A, B, C, D, F, Q, S, T, U from November 1st to November 1st, 2023 to December 16, 2024? I think that they want to offer.
D is not.
Oh, I'm sorry, D is not. You're correct, I apologize, I misstated that. So let me restate that. A, B, C, F, Q, S, T, and U.
So
From-
moved.
Okay, and do we have a second on that? Okay, I will call the roll. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Osfeld?
Yes.
Okay, so that subpoena will issue. I guess how do we want to do this to get the signature of the subpoena? I guess the board chair can sign it today, but I don't want to issue it until we have a revised writer. So do you guys want to, or maybe the better way to do it is
Working
just,
on it now.
okay. If you get it done while we're sitting here, email it to me and I can have the clerk's office print it. And we'll get it to you so you can get it issued straight away. Otherwise, my suggestion was gonna be, send it to me and Chair Raymond can just electronically sign it, send it back, and send it to the parties, and you guys can distribute it and serve it tomorrow. So, okay. All right, moving on. I think that the next subpoena that the board wants to review is the subpoena to,
Forest Ridge Academy.
yeah, we'll just kind of go in order of the packet, just to make it easy for everybody. And this is a subpoena to the Forest Ridge Academy, which I believe that the objectors are making an allegation that this is where the children of Napoleon Harris, or some of the children of Napoleon Harris attend school.
I move we deny that subpoena.
Is this the showing the address on file? at
Yeah,
the
this is to
children's
show, this is
school?
to show an address on file, and again, you know, it's just to show what address they're saying that they live at, other information.
Do we know it?
His children, they live there, maybe he doesn't, I don't think it proves residency for Mr. Harris at all, that's why I would deny it.
Well, I understand that, but, you know, he's gonna come in and testify, and this is cross-examination material, and I think it's relevant and appropriate, and, you know, Mr. Ladizinski, I made this same objection, and Mr. Ladizinski got this information in the last case we worked on.
No, I didn't.
Yes.
No, I didn't. I requested from your client, Thaddeus Jones, who happens to have a home in Calumet City, but lives in the village of South Holland with his wife. And he was asked to produce documents that he had received from the school with the address. Not the school. I asked the candidate. There's only 2 subpoenas. There's actually 3 subpoenas issued. One for his wife at South Holland, and 2 witnesses that were city employees that lived at that residence that he claims was his.
Member Osfeld, do you have any input? Oh, we're not on a motion, we are just discussing right now the subpoena to the forced.
I did make a motion.
Oh, you did make a motion, I'm sorry, what was, denied, okay. So we have a motion to deny the subpoena. Is there a second? For lack of a second,
It's Forest Ridge Academy.
or Forest Ridge Academy, thank you for the correction. I was just turning the page to see, make sure I had the right.
You know what, I think I would allow it, because the school may have records about where each parent lives.
So, like I said, perfect.
I would allow it. I realize he may not live with his wife and children. I have no idea the family situation, but that's something maybe we can find out in testimony. So I would be interested in the school records.
Okay, so as the electoral board attorney, I just want to say that, and also as a parent myself, I do have a lot of concerns about a subpoena going to a school, asking for any sort of information about children.
I think it's.
I feel that children, honestly, should be left out of this process. I think that you could, especially this is a private school, this is at a public school where you have to be a resident of that district to send your child there. These are private schools, I think that there's a big difference. And I think that, my personal opinion, as the electoral board attorney, I think it's opening up way too big of a can of worms. I think there's better ways to find out this information.
That was one of my motion.
I'll respect your opinion, and I did not realize it was a private school, not restricted by district.
Contract.
You mean my opinion?
So is
The
that-
motion.
So you can, I mean, if
So is there a
Member
second?
Swanson wants to remake his
Is there,
motion.
I do the motion to deny.
Second,
Okay, so we have a motion to deny the subpoena for,
Forest Ridge Academy.
thank you. I keep wanting to call it Forest Ridge Academy. That motion was made by Member Swanson and seconded by Member Raymond. I will call a roll. Before I do that, is there any further discussion? Okay. Chair Raymond,
yes.
Member Swanson,
Yes.
Member Oswald.
No.
Okay, so that carries as a denial of that subpoena 2-1. Okay, so the next subpoena that we are looking at here is a subpoena to the Illinois Secretary of State. That subpoena requests the driver's abstract for Napoleon Harris at both addresses, both the Flossmoor address as well as the Harvey address. Vehicle registration for any vehicles in the name of Napoleon Harris III. A copy of the driver's license for Napoleon Harris III and a state ID for Napoleon Harris III.
Go, Mr. Mullin.
I move that we grant that request.
I think it should be limited. If it's the motion is limited, I might consider seconding it. The driver's abstract, I think, is totally irrelevant to prove residency. That would just show if he potentially, if he's ever received a ticket or been involved in vehicle collision, received a ticket. Vehicle registrations and driver's license and state ID arguably would be okay, but not paragraph A of the rider in my view.
As the electoral board attorney, I would tend to agree with Member Swanson. I don't think that a driver's abstract actually shows anything as it relates to residency. It just shows whether somebody's potentially a good driver or a bad driver and how many tickets they have or do not have. And I don't think that that's relevant. I think that the information related to the address can be found both on the vehicle registrations, the driver's license, and the state ID. I see no probative value for the driver's abstract.
So I'll amend the motion to allow for the subpoena to go to the Illinois Secretary of State for the vehicle registration, driver's license, and state ID, and not to the abstract.
Okay, and would that be for both addresses, both the Flossmoor and the Harvey address, or?
Correct.
Okay. Okay, so we have a motion on the floor to grant,
So-
I'm sorry.
If I want to make sure that this is limited to these two addresses. He has a business, there's vehicles that are registered in multiple businesses. So that's what my concern is.
It's limited to those two addresses. And I will say, from my history with my father who sold auto insurance, I think that you can get in big trouble to claim to live one place and not live there when it comes to an accident. So that if somebody claims to live X, has an accident, the insurance company may very well deny it. So it's much more serious than just getting your bank statements at your office.
Understood.
And we don't have a limiting end date. We have headers that.
December 16th, is that correct?
Yes,
Okay.
that's my understanding.
That was what I understood as well. So we do have a motion on the floor to issue the Secretary of State subpoena, but to strike A on the rider, which is the driver's abstract, so it would be limited to the vehicle registration, driver's license, and state ID at both the Flossmoor and the Harvey address, and that motion was made by
Vehicle
Member Osmer.
registrations just limited to the Flossmoor and Harvey addresses specifically.
That's it.
So would not include, for example, if there's a vehicle registered to the pizza parlor, which is across the street from the one where he claims to reside.
I think you're getting part of this. My client is a former NFL player, and he is supporting many of his family members. I don't want that information out there. And it's already out there now because it's a public meeting, but that is one of the biggest concerns I have here.
Understood.
So would those, Mr. Ladazinski, just so I understand your point, does that mean he may have vehicles that are in his name personally that are really for the use, sole use of a family member potentially?
His name may appear on vehicle registrations with that other family member. That's what my concern is, like, you know, someone couldn't afford to purchase a car.
But the request is limited to the two addresses.
Well,
So I think, I guess, Mr. Mullen, if you get anything that is unrelated, I mean, I understand, you know,
But I go back to my concern here, is this is politics. They represent an opponent in this race, okay?
do you want the subpoenas to be returnable to me?
Yes, I want all the subpoenas returnable to the board.
And then I'll just distribute the responsive stuff after a quick review to make sure that there's no issues, and I can even, I can even send it out in a protected PDF, a password coded PDF. That could be a potential solution, to try to figure out a way forward that everybody would feel comfortable.
I think there should be any vehicle registrations solely in the name of Napoleon Harris at those two addresses.
It is, it says vehicle registration in the name of Napoleon Harris III, driver's
Solely.
license for Napoleon Harris III, and state ID for Napoleon Harris III, and it is limited to the two addresses. So, but if the parties would like it, you know, have the subpoenas returnable to me, I'm fine with that. Obviously, it's gonna increase my workload, but, yeah, if that would make everybody feel a little bit more comfortable as to the sanctity of the documents. And like I said, when I do send them out, I'll send them out password protected. Does that work? Is that okay with the board?
Yep.
It's fine. Okay. I think that is possibly at least a fair, fairer solution. And if that way, if the subpoena from the Secretary of State comes through and it's got a different address, I will alert the parties that it came through with a different address, but I'm not gonna be giving it to everybody because it's not responsive to the subpoena.
Okay.
Okay, I think that's an elegant solution to a complicated problem.
Could we take a 5-minute break?
Yes, I need one myself.
5-minute break. You guys thumb up the video if you can. Support the channel. I'm not good at commentary, like critical in the breaks, but I see you guys in your comments. Thanks for being respectful in the chat. Thank you to my moderators as well. Thanks to all that liked the video. We have 279 people watching. Thumbs up. We're on number C. Number C, letter C. We're on letter C, guys. I'm so tired. We're on letter C, and we're still going. So we shall see. So it was the lady on the screen. She represents a law firm. So we can't really hear her that well, but that's why I moved so y'all could see it was someone talking on the screen. Also on your right, you have everybody that's for the right from they got some lawyers. Keith Price and Michael Smith got the lawyers today. They definitely are challenging, so it's a little different than when we heard Keith Price and Mike Smith. Then we got Letta Dinsky. He's representing Napoleon Harris with his people, and it's quite interesting because y'all, has this made y'all think about what you have registered? I too, I pay a bill for somebody, and I just pay it every month. It's just a cell phone bill, but it goes to their address, and it just comes out my account. So it makes you think about when you get into public service, how you have to dot your I's and cross your T's. I understand he's a ex-NFL player, and he might help out a lot of people, but I think the bottom line is he's a public servant as well. So that's the problem. You know what I mean? So how did y'all feel about the school when they were saying they want to, me, I always get sensitive with kids, so I was like, oh no, don't bring the kids into it. And I didn't think he was gonna have to come up here and testify. This is quite interesting. I thought today was the last day that we had to be through this. Car insurance, that was interesting. Clerk Wells is here. Now, if you guys didn't know, Stephanie Wiedemann is here. Clerk Wells is here. And you remember, she told the board, y'all can have that, baby. Y'all can have that. She was like, I do not want to be I think she made a smart move. So we have a new hearing officer, and she's doing a pretty good job being fair. And it was a new face. I don't know where she's from, but it's kind of cool to have a new face that's not the same faces we see repeatedly. You know what I mean? So that's pretty interesting. Oh, yeah. So hopefully Critical and Reality Check are here for when Napoleon testified. I didn't even think they were going to subpoena people, y'all. I'm like, can't we just show an ID and call it a day? This got deep. I was just thinking we was going to show a driver's license and go on home. You know what I mean? So I didn't know it was this deep. So now it's going to be a whole hearing within 5 days. Thank you for being here, News for Reasonable People. You're going to have interesting content today. I'm just filling in for a Critical and Reality Check. Once I see they're not coming, I just pop my head in. You guys thumbs up the video if you can. Support the channel on the Boots coverage. You don't have to. Thumbs up if it is enough. Oh, the likes went up. I appreciate y'all. So this is interesting, and this is quite challenging. So we got two more things. We got two more things on here, and you guys can find this on the Thornton Township website. Okay. So we got we got Keith Price and Michael Smith against Napoleon Harris. Then Keith Price et al. Napoleon Harris. And then Keith Price and Michael Smith versus George Baker. So we haven't got to 3. So thumbs up for lunch. Thumbs up for lunch. Oh, you know what? I think I brought me some crackers. I brought some crackers and I brought some water. But I'm running out of my water, so. I should have brought 2 bottles because these hearings are long. Can anybody put the time in the chat from what's our time in Illinois? Because I didn't have 2 phones today. Okay, so, yeah. So they need a 5-minute break. This is quite interesting. Could this be a possibility? They can't prove residency. I thought this was gonna be open and shut and thrown out. It's not looking like it, you guys. So could it be a proof that they can't show residency? It could be. And we're stuck, what will happen? Would that mean, did anybody hear about Nate Fields today? Did he get on the ballot? Did the judge approve it? Did anybody hear that? Because he had that case today. This is interesting. So, would that leave just, would that just leave, would that leave just, Wait, did you hear, that was Keith Price saying, "Hey, trustee," to Stephanie, we, and she just smiled. Did y'all hear that? I didn't know if y'all heard that. Hey. Ooh, thank you guys. Thanks for giving me an update. They not made a ruling? This is really interesting, This is interesting. This is deep. This sort of makes you realize, have all your ducks in a row. If you don't, because if you're definitely going into public service, you're going to have to prove that. I'm like, what? I thought voters registration was enough, but as we know, people get voters registration. They claim homeless. They claim their parents' address. That happens. Okay, just give me an ID. I thought that was enough. Child, they done went to the car insurance, library card, kids' school. Man, I do feel like some beggar's pizza for dinner. I'm hungry, guys. So you guys just enjoy the chit chat going on, and thank you so much for liking the video. And hopefully this is not too long-winded. What the news for reasonable people say? I'm sorry, y'all. I can't see. The comments are so fast. So who is backing up candidate? Yeah, that's a good question. That's what I'm saying. Oh, look at Stephanie and Max Solomon. See, everybody's congratulating her. That's really cool. I'm so happy to see people be people. You don't have to be. I'm glad she actually got that. Like I said, it was poetic justice. She was the best person for that spot. I'd like to see people who are people. You don't have to be on a team. You don't have to be against anybody. You're just people. We ain't have none of that. Scott, what is he in there doing? Scott cutting up. What is Scott doing? Hey, Lana. Oh, okay. So thank you, Shan Marie. The judge will put in writing his at the end of the day. Ooh, this is interesting. Hey, Miss Asia. Oh, I forgot about Clark. He sure is on. Ooh, this is interesting. Y'all can, okay. Let me go get my crackers, you guys, so I don't faint up in here and they be a miracle on Thornton Township Street. Just passed out. Let me go.
All right, parties, are we ready to go back on the record? All right, is everyone ready to go back on the record?
Yes.
Mr. Mullen?
Yes.
Okay. All right, so we are back on the record. For the record, we took about a 5-10 minute short break. Where we last left off was we were discussing the subpoena to the Secretary of State. I believe that all the parties have agreed that not only will the subpoena be limited, but all responsive records to all the subpoenas will come to me as sort of a clearinghouse, as the electoral board attorney. I will review the responsive documents, and if there's anything that I think is not responsive that's outside the scope and that invades privacy, that is, again, outside the scope of the subpoenas, then I will return that to the sender and say that this was not responsive, we don't want this.
So I just want to be clear, with regard to these subpoenas, many of them are asking a human to come to testify with the documents, so I don't know if you'll be receiving many documents.
So that is a fair point. I mean, the documents from Mr. Harris, I don't need to see those beforehand. You're his attorney, you're gonna control those. I think we're talking about the third-party subpoenas.
After they serve them.
Correct. And we're talking about the third-party subpoenas. So, you know, as it relates to those coming to me. So are both parties in agreement that the third-party subpoenas, not the subpoenas for the candidate or any other family members, if those issue?
The ones that ask for
Correct.
Yes.
So, yeah, so for the Secretary of State one, it does say we demand your appearance, but as we all know, it's really a subpoena for documents. So, in fact, if you can just, I know that that's the traditional language we use in subpoenas, and I don't really understand why, if it's a subpoena for documents. If you just want the documents, why you have to demand the appearance?
But because you need foundation.
Well, true, but if they're coming in through subpoena,
You need foundation.
so you're gonna want somebody from the Secretary of State here to testify to?
There's ways of doing it.
Okay. All right, well, either way, we'll have them returnable to me. I would put I guess that begs the question, we've got the next hearing date as the 31st. But if I'm gonna review these in advance of that, then I'm gonna need them by the 30th, but we don't want them to come in early on the 30th. So how do we wanna do that?
They shouldn't be coming in.
So what I was saying is that the next hearing is the 31st.
Right.
If we want me to review them sort of as a clearinghouse and them come to me and then me distribute them and have them be returnable to me, then what date?
They're returnable here,
Correct.
except for the ones that are for documents only, and there are not that many for documents only.
So with those, with the ones that are for documents only, such as the Secretary of State one and some of the other ones that we're gonna be going through, I think we need to adjust the return date on that and make it not the 31st and give me a day or two to take a
Yeah.
look at it so then I can get it to you guys. So
29th.
I was just gonna say the 29th. Are you?
It's 3:20 on Friday, so if I'm the Secretary of State, I'm not gonna get served until Monday morning, and you're giving them, less than 48 hours to respond to this.
Do we want to say the 30th then? I'm just trying to figure out a way forward, otherwise we can use the next hearing date to kind of go through the responsive documents, and I don't think that's what anybody wants to do. I think we want to get to the hearing on the 31st.
Member Hospital has planned, so
Right, so,
Don't offer.
well, I'm just trying to figure out a workable mechanism. If we're going to have the subpoenas returnable to me, how about this? How about let's finish going through the subpoenas. Why don't we do this? Why don't we finish going through the subpoenas, and then the three of us can figure out how we want to make this happen.
I mean, I've never seen a Secretary of State subpoena come back any thicker than this. I mean, they're just not.
Well, we could just keep it on the 31st, and I guess whatever comes in, I'll take 5-10 minutes to review, but that's not gonna give anybody any opportunity to make copies and stuff like that, so. Okay, all right, then we'll just make it on the 31st, if that's,
Yeah, I mean,
okay.
if you take a look at the subpoenas, my concern are, they say, you provide these documents ahead of time, your appearance may not be required. So I don't want documents just being sent unless they're going directly to you.
Okay. Then we'll make it returnable to me, but we'll keep the date on the 31st. Okay. All right, so, Dan, when you are drafting those over there, if you could make them returnable to me at my law firm address, which is 1441 South Harlem, Berwyn, Illinois, 60402. And if they need to, if you need to put a phone number on there, you can put my office phone number, which is 708-222-7000. Yep. Okay. All right, moving forward, so now we need a motion to approve the issuance of the subpoena for the Secretary of State, limited to items B, C, and D, and only covering the Flossmoor property and the Harvey property. Do we have a motion to that effect? Okay, we do have a motion from Member Swanson to issue the subpoena as modified and as discussed. And we have a second from Chair Raymond. I'm going to call the roll.
No, second.
Oh, I'm sorry, checking from Member Oswald. I apologize. I will call the roll. Chair Raymond?
Yes.
Member Swanson? Member Oswald?
Yes.
Okay, the subpoena will issue as discussed on the record.
And I move we approve the subpoena to Dolores McGee as drafted.
Or we can get the plan.
No, we're going through the packet.
Oh, I missed the page? Oh, I missed the page. Okay.
Okay, so we do have a motion from Member Swanson to issue the subpoena as drafted. And just for the record, this is a subpoena for personal appearance, correct?
Yes.
And this was the neighbor?
Yeah, this is the person in the house adjoining the Harvey address.
Oh, these are connected?
Yes.
Not the neighbor, y'all. My God.
Okay, so we have a motion from Member Swanson, second from Chair Raymond to issue the subpoena to Dolores McGee as presented. I'm going to do the roll call. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Motion carries. That subpoena to Dolores McGee will issue.
Right, and we will withdraw the subpoena request to the Illinois State Police.
Okay, I will note that on our packet. Obviously, I'm assuming that the Candidates Council has no objection to the withdrawal of that request.
I have no objection to that.
And we'll remove our request for sanitation prep.
Okay, duly noted, and Candidates Council, no objection, I assume?
No objection.
Thank you. The next one we've got here is National Passport Center. All I gotta say on that one is good luck.
I trust me, yes. I'm not, I don't have authority to withdraw it or to the postmaster, but I don't expect a response.
I gotta fathom that they can't turn out passports in a timely manner. The responses to subpoenas may take a little longer, but I don't know, I've never tried it.
You do not have jurisdiction to issue subpoenas out of this jurisdiction.
And truthfully, I mean, my opinion is I think that there's enough documents here that are subpoenaed, otherwise I don't know about the jurisdiction to issue the subpoena outside the jurisdiction. That's something I would have to look at. I think that he's saying that we can't issue subpoenas to national agencies, only things within the state of Illinois.
The uniform enforcement of subpoenas only applies to subpoenas issued in litigation matters that are pending in courts. They do not apply to administrative subpoenas.
Do you want to withdraw that knowing it's not going to happen?
Yeah, let's withdraw that from the postmaster and then the Carl Washington.
We have no objection.
Okay,
So,
give me a moment, let me
is the
make sure.
subpoena to the passport office, was that withdrawn?
Yes, that is withdrawn. That as well as the postmaster, so we are now on the subpoena for Carl Washington, and Candidates Council has indicated no objection to that. So the subpoena to Carl Washington, we just need a motion to approve the subpoena.
So moved.
Second.
Got a motion by Chair Raymond, Chair Raymond and Member Swanson, and second by Member Swanson. I'm going to call the roll. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Motion carries. That subpoena will issue.
Now, just for my clarification, was the passport subpoena withdrawn?
Yes.
Yes,
And the one to the postmaster
Yes.
general?
correct.
Those were both withdrawn.
Yes. Okay, so moving forward, we are now on the subpoena for Nicole Harris.
That's the wife.
That's the wife.
And we would ask that that be limited the same way as the subpoena to the candidate.
And as I am drafting that now specifically, that would be to paragraphs A, B, C, Yes.
And they were identically
Yes.
worded to begin with?
They're the same as you approved to the candidate.
The subpoenas were not identical in that there are 2 more paragraphs in Napoleon Harris, but the letters I just named correspond with what was previously approved.
So,
Yes, yes. A, B, C, F, N, Q, R, S.
And Ms. Fox,
Pardon me, this is why we were doing this. Then I believe we would have left in O, is that correct?
yes, but now these are in her name and not his name, correct? This is her driver's license?
Yes.
I mean, does the board see the relevance? I mean, if we're already getting the
I don't see
subpoenas.
the relevance to her driver's license to his residency.
We don't know their relationship.
My recommendation would be to deny the subpoena.
So moved.
Wait, deny the subpoena entirely?
Yeah, to Nicole Harris. I don't see the relevance of subpoenaing his wife as it relates to her, I mean,
But
like the board was saying.
she knows where he lives. She knows where he sleeps, so she should be able to testify to that.
But these documents,
Okay, then we'll take the rider off, but we want her here to testify.
okay.
Okay, any response, Mr. Ladisinski?
malicious mischief,
I love the
malicious mischief.
It's gonna be my.
What does the board think on this?
Yes, I would like to hear from Nicole as to where her husband lives, so how do we word that?
So, the wording would just be to issue the subpoena for personal appearance and testimony.
All right.
So moved.
Okay, so we have a motion by member Raymond to issue the subpoena for personal appearance with no right. Member Oswald.
Yes.
Okay, the subpoena for Nicole Harris will issue solely as to her personal appearance to come testify.
This Bank of America was on.
I was just gonna move over to that one. Mr. Mullen, what is the plan on the Bank of America one?
Sorry, which one?
We are on Bank of America,
Okay, we'll withdraw that.
okay? And I assume no objection, Mr. Ledizinski?
No objection.
Okay, thank you. And next one is Homewood Flossmoor Park District. That's one that the candidates, I'm sorry, the objectors had stated that they wanted to keep based upon the reasons that Ms. Kraftheffer had stated on the record related to resident rates, non-resident rates, and so on. I do note for the record that the scope of the subpoena relates to both the Flossmoor address as well as the Harvey address, and it states any and all documents such as membership documents that reflect the address of Napoleon Harris III, any and all documents such as membership documents that reflect the residence of 1405 Dumfries, Flossmoor, Illinois. And again, this is to the Homewood Flossmoor Park District.
It does not have a relevant time period.
That is correct. I don't see any sort of limiting time period on here.
Well, we're happy to do that. We're just asking for what the current address on file is, so it doesn't go back in time at all.
You want today's address? Are you looking for the current address today or the address when you filed the statement of candidacy?
Like, we'll put the time period in there.
Are you talking the November 1st to December 16th, 2024?
Yeah, I mean, my only concern was, you know, he might have filed his application, 4 years ago, right? But it's current as to what his address is now.
It is not the role of this board to help the objector redraft subpoenas.
Understood.
I mean, the reason, the rule provide your draft subpoenas, and these should be denied outright. If you can't get it right for the time period, and we're gonna spend this time helping Mr. Mullen draft them correctly, Ms. Carecrafter, I have an objection to that.
Understood, point taken. How does the board feel about that?
I think we can limit what we approve in a subpoena. I don't think our hands are tied to put a date restriction. And I think we said at the beginning that that date period would apply to all of the subpoenas, but we're just saying,
No, and
Remember to
we
add
said
it.
we'll add that, yes. But I was just explaining, we didn't necessarily,
Yes, Pickles.
I didn't
Yes.
include it in the original because the application might have been previous to that, but we'll add that limitation.
There's a question I have because it's referring to all people who live at that address. And I would go to only the candidate because if the claim is that he's living there with his family, you're talking about children. Children shouldn't be involved in any of this. So I would move that it is accepted to the exclusion of anybody other than the candidate. And
So you would eliminate B and keep A.
You would eliminate B in the rider?
I don't have a copy of that. I don't have the writers. Yeah, I would eliminate B.
Okay. So any other board members have any comments?
am I looking at the right writer? Was B
Yes.
concerning Flossmoor?
Yeah, it's, yes, because this is a subpoena to the Homewood Flossmoor Park District.
Oh, I'm sorry. Okay.
So Member Osfeld has suggested the elimination of B. So Member Osfeld, since that's what your suggestion is, do you want to make a motion to that effect?
I move that we allow the subpoena to the Homewood Flossmoor Park District with the exception of paragraph B
And-
for the time stated.
And inserting the deadline of time.
So
I'll second it with that modification.
Okay, so just for clarity, so that all the parties are aware, the board has made a motion to issue the subpoena, however, only as it relates to item A in the rider, and to limit the scope of the subpoena to November 1st, 2023 to December 16th, 2024. So we have a motion on that, I'm sorry, and Member Osfeld made the motion, Member Swanson made the second, so I will call the roll. Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Motion carries.
And so with respect to the next one, which is the Flossmoor Public Library, we will, voluntarily agree that that would be the same as the Park District.
So we're taking out B.
Yes, and
I'm limiting the scope of time.
yes.
Okay, does the board, how does the board feel about that? Does the board want to make a motion? Is there any other discussion?
So moved.
Okay, so just to be clear, there's a motion on the floor to approve the subpoena to Flossmoor Public Library with the limitation of removing item B on the subpoena and the limitation of the scope of time from November 1st, 2023 to December 16th, 2024. Do we have a second on that motion?
As modified, I'll second
Okay, thank you. I will now call the roll. Chair Raymond?
Yes.
Member Swanson?
it. Yes.
Member Osfeld?
Yes.
Okay,
And
the next one
The next one is for the Village of Flossmoor for the parking pass that is only for residents, and we would request that that be approved with the same modifications as the last two.
Okay, and for the record, the subpoena requests any and all, and it doesn't have a time frame, but as we've discussed, we're limiting all of these to November 1st, 2023 to December 16th. The subpoena requests in item A, any and all documents such as vehicle stickers or applications for vehicle stickers that reflect the address of Napoleon Harris III. And B, any and all documents such as vehicle stickers or applications for vehicle stickers for any residents of 1405 Dunfree Street, Flossmoor, Illinois 60422. So just to be clear, you're also going to remove, or you're saying that you'll remove item B, so it's just item A?
Correct.
Okay. So this is similar to the last two that the board just did. Does the board want to issue the subpoena as, hold on, Mr. Ladizinski has a comment?
The objection I stated before, if he's paying for someone's vehicle sticker on a vehicle that have made purchase for someone that's a family member, I mean,
You can testify to that, but I think we're still entitled to the document. In order to get a parking sticker, you have to show that it's your car and you live there, so it's relevant.
but if a relative comes in, relative is living in Flossmoor and gets a parking sticker, and Mr. Harris's name is also on there because he's on the title of the car, what does that have to do to prove that Mr. Harris is living in Flossmoor?
So won't you explain that to us at the time then?
This is exactly what I'm concerned about, is my client have to testify about what I would say generosity and good deeds. I was always taught about generosity does not have to be something that you should be talking about publicly, you just do it.
Is it, our department asks, are they limited by address of the person?
It depends on the
says-
municipality.
Yeah.
It says Flossmoor residents must purchase and display a vehicle sticker to every vehicle that is registered to or housed within the village. So it says Flossmoor residents must.
Less limited to a registered, the Dumfries address.
Yes.
Yeah.
Is that acceptable, Mr. Blazinski?
That's acceptable, we'll see what the document that gets produced has.
And that should be another one that's returnable to council?
Yes.
And, you know, one other thing, if I could just go back really quick, what I noticed in the last couple subpoenas, and I apologize for not noticing this. In regards to the writer, when you guys are sending back the writers, as it relates to the ones that are going to Flossmoor, like the Flossmoor Park District, Flossmoor Village, Flossmoor Library, you do still have the Harvey address in the opening paragraph of the writer. It says, you know,
We'll take that out.
Okay, all right, just want to make sure that that was noted. Okay, so then if you could also, we'll have the board vote on this momentarily, but my understanding from what I just heard from the board is that they're okay with the Village of Flossmoor subpoena, provided that it's limited to the Dumfries address.
Yes.
Okay, so,
Move on that, I think we may need a motion by the others as well.
no, I think we made it clear on the record. I think it's clear enough on the record. If they come through and it's not consistent with what the board has discussed and ordered, then I'll just send it back and say, fix it. Okay, that said, if we can have a motion to approve the subpoena as modified and as discussed.
So moved.
So we have a second?
Second,
Chair Raymond?
yes.
Member Swanson?
Yes.
Member Osfeld?
Yes.
Motion carries. Okay, the next one is Nina Graham.
Move approval.
And this is solely a subpoena for testimony from someone who is a personal friend of the candidate and has knowledge of where he resides.
Was there an objection to this?
I think with regard to O, P, Q, R, and S, and
There's no writer.
Where are you getting that?
there's no rider to any of them, so I'm assuming these are just personal appearance
Yes.
subpoenas for people to testify, and that they believe that these people may have information.
That is correct.
So you have no objection to the Nina Graham subpoena?
Malicious mischief, go at it. I know they will not be very happy with Ms. Graham's testimony, so.
Okay, so do we have a motion from the board to issue the subpoena to Nina
So
Graham?
moved.
Do we have a second? Okay, so I have a motion by member Osfeld and a second by member Swanson. Chair Raymond,
Yes.
member Osfeld,
Yes.
member Swanson. Motion carries.
That was the
Nina Graham,
Okay.
correct. And this is that's a personal appearance subpoena. Next one, we have another personal appearance subpoena for Charles Chuck Gibbons. I think I'm saying that right?
Gibbons.
Gibbons, oh, okay. With the ES at the end. With a personal appearance subpoena for Charles Chuck Gibbons?
Yes.
Okay, so,
And all of the ones remaining are from our investigation, so they're all just personal.
okay, then let's do this in a bulk manner. I guess I'm gonna read off the ones that are remaining. Mr. Ladazinski, let me know if you have any objection to them. If not, we'll do a bulk approval. Chuck Gibbons, Charles Chuck Gibbons, any objection, Mr. Ladazinski?
No.
Rochelle McMullen,
No.
Brian Allen,
No.
Barry Johnson,
No.
Cynthia Alexander.
No.
Okay, there's no objection. Can I get a motion to approve the issuance of these personal appearance subpoenas?
I just have a question. How much time are we talking about these people testifying?
She like,
This is, I mean, if the, the board is certainly within its powers to limit the number of witnesses. I mean, if it's gonna be, if it starts to become repetitive, we can, number one, the board can excuse witnesses. That's the first thing. Or if the board wants to, ask the candidate to give, or I'm sorry, not the candidate, the objectors, to give more information as to why all of these witnesses are relevant. Because you're right, Member Osfeld, this is gonna be a marathon hearing.
I will just state for the record, in light of all of these witnesses, we will not, speaking for my colleagues at that liberty, we will not tolerate cumulative testimony, and they may appear at the hearing, and we may not allow them to testify if it looks like it'll be cumulative.
yes,
All right, then I
yes,
move
loud
to,
room, yes.
Grant the subpoena.
Okay.
Subpoenas in plural.
Okay, so the personal subpoenas as read, do I have a second on that?
Second.
Okay, Chair Raymond,
Yes.
Member Osfeld,
Yes.
Member Swanson,
Yes.
motion carries. Okay, so the personal subpoenas as read will issue.
Then there's one last subpoena. That's their
Oh, yeah, the
supplemental
NFL
request to
Players
the,
Association?
yes, the NFL Players Association, Washington DC.
And we'll withdraw that.
Okay. That was in the supplemental.
Oh, the supplemental.
Yeah, that was the supplemental.
Oh, my.
All right, so, I don't believe there's anything further today as it relates to this case.
Yes, there is.
Oh, there is, I'm sorry, what is
The candidate's request for the objectors.
Oh, goodness, I'm sorry. I've been going through all the objectors. I apologize, I forgot about you guys. Okay, oh, I got it. Okay, so for the record, the candidates have requested the issuance of subpoenas to, I believe, Mr. Price, Mr. Smith, and
Jerlene Harris
Jerlene Harris and Ms. Harris.
and Christopher Clark.
Okay, and to the objectors, I know that there was some objections lodged as it related to the issuance of the subpoenas. I know that there's been, earlier in your argument, you were even stating, as it relates, and Ms. Crafthoffer was also stating, as it relates to the objectors, that how they came up with the objection is not relevant, but they could testify to their personal knowledge. Is that my understanding of what your argument was?
In their evidentiary case, yes.
Okay. And Mr. Ladazinski's obviously arguing that they should be here, that they have filed a verified complaint, verifying that they have personal knowledge, not that they just have information and belief that he wants to probe that personal knowledge. What does the board think?
We authorize all 4 subpoenas to Christopher Clark, Keith Price, Charlene Harris, and Michael Smith.
I question the relevance of Christopher Clark. How is he related to this, what's before us?
Well, it's going to be relevant to, for example, you're going to be receiving, or they've already put in front of you, a summary of a bill from the city of Harvey for the Harvey residents of Senator Harris that's listed as vacant. Mr. Clark is the mayor of the city of Harvey. We will be, if the objectors are able to proceed with their case, we will be introducing correspondence from Mr. Clark to Mr. Harris at the Harvey residence. So the issue of if they're going to be introducing documents from the city of Harvey, and an opponent in the case is the mayor of the city of Harvey, and the city of Harvey is producing documents that say the property is vacant, it's relevant to the veracity of those documents.
And what does the objectors, do you object to that? Or?
I don't see the relevance of that in particular, but, you know, we've subpoenaed people to testify because we believe they have personal knowledge, and I'm not going to object on those grounds. If you don't believe the testimony is relevant, then, you know, it's not admissible.
We can rule on that at the time of the hearing.
And then with regard to our subpoena, we have a typo. It says Harvard versus Harvey on Mr. Clark's subpoena. We
Okay,
just
so you
correct
said
that.
it's a
Yeah.
revised subpoena? Yeah, because we don't want them going all the way up to Harvard, that's a
Right.
really long place, long drive.
But he said we do not revise the subpoenas, or not to read it according to what he just, but we will,
Okay, so we have a motion on the floor by Member Swanson to issue the subpoenas as presented. Do we have a second?
I'll second.
Okay?
I would modify the motion as corrected, the typographical.
Yes, and yeah, correcting the Scrivener's error. No problem. So the subpoena will we'll do the roll call. Chair Raymond,
yes.
Member Swanson,
Yes.
Member Oscar.
Yes.
Okay, the subpoenas to the objectors, Keith Price, Michael Smith, Jerlene Harris, and Chris Clark will issue with the corrections made by Mr. Levizinski. And both parties, please send me the corrected ones. I will send them over to the chair. We'll get the signatures, and again, just make them, any subpoenas or documents returnable to me as discussed.
Did we issue a ruling on candidates' objection to objectors' request and supplemental request for issuance of subpoenas by going through them one by one, or did they need to issue?
No, I think that going through them one by one addresses the concerns.
Okay.
And, they requested subpoenas, they filed objections, we took everyone's objections we took everyone's objections to the subpoenas into consideration, or the board did. When I say we, I mean them. So, yeah, I think that you're fine on that.
Okay.
The only last matter would be disclosure deadlines for evidence and witness list.
Yes, I normally figure 24 hours, because sometimes things come in a little late. So is 24 hours good for the parties, or do you need more time? Do you need 48? And again, this is a deadline before the hearing.
Right, what time is the hearing again?
11:30. I have 11:30 in our subpoenas.
That's what I have.
And we will not be here until what time was the hearing? About 1:30 in the morning?
1:30 in the morning.
So we will not have.
I guess, well, part of that, I guess my question is, can we do it earlier than 11:30? This is,
The problem, we can do it earlier, but I have a court hearing at 11 o'clock. So what I'm going to do is come here, and then if you want to start, and then I can take a brief break, I'm going to notify the judge of what's going on, but there are other people involved.
Would the parties be agreeable to starting at 10 a.m., taking a brief,
I'm not-
11? Okay, so we're, 11:30 is it?
11:30.
Okay, 11:30 is it? All right, I was just seeing if there was a way to, open it up.
You missed this one quickly.
Well, you know, I think that, you know, the board, obviously, we gotta make sure to give everyone their due process, but the board does have some tools in its tool belt to limit the scope of things and to limit, again, you know, as Member Swanson had said, you know, we're not gonna entertain repetitive testimony. And, you know, if the witness is being unresponsive, you know, that's obviously gonna be problematic. So the board will, you know, deal with that appropriately. Let's set another date the following week. Assuming,
Here's the problem with that. I've got vacation plans starting that Sunday to the following Sunday.
is there, well, we can always do it. So here, let me get through my thought real quick. So my thought is that more than likely, I'm very hopeful that we're gonna get through all this on the 31st, right? So I'll try our best to get through all this on the 31st. If we do, we should set a tentative date the following week. Because if we get through all of it on the 31st, you guys can vote to make the decision on the 31st. The rest of the board, without you, could meet the following week and sign and give the decision. Because what we do need to do is we need to remember, not only does a ballot need to be certified, but the parties need to be given their opportunity to file any sort of petitions for judicial review that they may need to file or want to file. So I want to be mindful of that. And I also don't want to get, you know, Janelle or our new clerk, Monica Gordon, upset with us for taking too long to hear these cases. So we got to keep these things moving along in a very expeditious manner. So my suggestion would be on the 31st, let's try to do this to completion. You guys hopefully will issue a decision on the 31st. Then I will draft the written decision. We will come back the following week and issue and tender the written decision in open session as required by the election code.
Would that be Tuesday, February 4th?
I could try to do Tuesday, February.
Let's be here like for an hour.
Wait, what? Let's be here what?
Let's be here for a while.
Why, what happens on the 4th?
You have great kids, I guess.
Oh.
I will say that
Malicious mischief.
I will admit that.
I am available Saturday, the 1st.
No, I could not write a decision in one day.
I'm available the 1st, 2nd, and I'm also available by Zoom. You said that if it's a personal matter, I couldn't do Zoom.
Yeah, let's do the,
fun.
can we do the 5th? Can we do the 5th? Can we do the 5th? Can we do the 5th?
5th works for me.
5th does not work for me. 5th, 6th, and 7th are all bad. Well, yeah, all bad. The Monday and Tuesday work? The third and
No, I'm not gonna, I mean, I've got a brief too.
Oh.
I've got to write a decision with a whole bunch of testimony.
She's stressed out.
He's not-
She's stressed out, yeah.
So I don't have any control over that. It was her schedule, she said it and I agreed to it.
This hearing, if we set a tentative, we set this tentatively for Sunday, how long it is?
Just to sign it.
10 minutes. But Tiffany has to get here.
Just to write it.
Hold on. Yeah, that's the thing, I have to write it, you know, I mean, I have to write the decision. I'm pretty superhuman, but I'm not that superhuman.
The chair can write it.
I've never had that happen.
Well, I could do
We want to hear a word you say.
Right, or you could just,
Is this on me?
no, I'm sorry, we should totally be not on the record right now, I apologize, let's go off the record, because we're just talking about scheduling. So, yeah, I guess we could do the 4th, Hannah will just come and give the written decision on my behalf, and then I will be working on that response for a reply brief to you, and we all just kind of switch spots in this little world.
Yes.
Musical chairs.
So what time on the 4th is?
That's up to you guys.
1:30?
1:30 on the 4th, does that work for the parties?
Yes.
The 4th at 1:30.
I just love double booking myself. Got 2 briefs due on the 29th.
She's stressed out, y'all. She's like, look, get somebody else to do it.
That's because I don't sleep.
Yes, oh, didn't I be emailing you? She's the only one that answers me at that time.
I need my sleep. Why?
Exactly. Okay, so I think we can go back on the record, we've got a schedule. So, just for the record, we will return here on December 31st. On January, goodness gracious, January 31st, thank you, 2025 at 11:30 a.m. And then we will return again, hopefully for issuance of the decision on February 4th, 2025 at 1:30 p.m. Yeah, that was what I was suggesting. Are the parties good with 24-hour disclosure rule? 24-hour evidentiary and witness list disclosure rule?
Mr. Mull?
Are you okay with the 24-hour evidentiary and disclosure, evidentiary and witness list
So
disclosure?
Thursday, 11:30.
Correct.
The exception that anything that comes in from subpoena after that is.
I'm fine with that.
Yeah.
Okay. All right,
What do you
so
do about the other cases on our docket today?
we're gonna go through them very quickly.
Good.
All right, so there's nothing further for this case today. So, Mr. Mullen, you're excused.
I'll have those updated subpoenas to you in soon.
Okay, great. I'll make sure to copy Ms. Otten as well. Okay. While you're doing that, I'll call the other cases so they can come down. Okay, thank you. All right, so the next case we are going to call on the docket is 25 TOEV Soup 01C. And that is Keith Price and Michael Smith versus Napoleon Harris. I do see Mr. Max Allen, you're at the table with them. Are they no longer pro se? Are they now being represented by counsel?
Thank you, Council, for asking. Good afternoon, Madam Chair and Council. Yes, Maxwell. I would be asking to allow me to enter my appearance on behalf of the
Does the candidates council have any objection?
If he's here to ask for a continuance and everything, yes.
Okay, are you ready to proceed today?
Well.
I therefore have an objection.
I would not recommend any continuances. We are so close to certification, we were past certification. So,
And thank you for clarifying that. I do understand that, Madam Chair, I was going to be asking to accommodate it since this is the first time or the second time the board is meeting, I understand. And this is the first time that I'm going to be appearing before this board. We have a candidate of the objector. To the extent that that request will not be met in paper, then I will be ready and willing to proceed with oral presentation on this regarding the motion to dismiss with this petition. And then to the extent that this board would deny that motion to dismiss, then of course we will go to the
okay. Okay, does the board want to entertain any sort of continuance or just want to hear argument today?
Today,
Okay, there you go. I don't even think we need to take a vote on that.
like we did earlier.
Yeah, limited to 10 minutes per side is what we did in the other case, so we're gonna impose, the board's gonna impose that limitation on this case. So with that, Mr. Lezinski, you have the floor.
I will try to do the outline like I did for the first motion. This is the objector's petition that's missing a page. Front page, last page, middle page isn't there. And on that middle page are all the key allegations that relate to whatever remains in this objection. First of all, with regard to the residency objection, they say, number one, residency is all on page 1. A short, succinct objection. But these two objectors have filed a petition beforehand. You can't get 2 bites at the apple. You can't sue people twice for the same thing.
Did I interrupt? Are we hearing residency or was that what it's on by both the objectors?
Oh, that's more malicious mischief, Miss Raymond. Is there?
Madam Chair, you're correct. The issue here is no longer residency, it's not that the objector have withdrawn residency objections in that petition.
No, they have not. There's a series of emails where Michael Smith says, yes, I want to withdraw. Keith Price says no.
No. So just for the record, the emails were, Mr. Smith said he wants to withdraw from everything. He said he wanted to withdraw the caucus objection as well as the residency objection. Mr. Price said that he only wanted to withdraw the residency portion of the objection, that he wanted to remain on the caucus objection.
And there's a dispositive motion pending on the residency, okay? And they already have another matter pending. You can't piecemeal, you can't split your claims in 2 separate filings when they relate to the same facts here. And the same facts here are the candidacy of my client.
I think the board is definitely inclined to, both based upon the representations of Mr. Price and Mr. Smith, as well as the dual objections that were filed, I think the board is inclined to dismiss the residency objection.
On this case, I move that the objectors, on that issue of residency, if a motion to dismiss on the issue of residency is granted.
Second,
Okay. Chair Raymond?
yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Okay, so the motion to dismiss as it relates to the residency objection is granted.
Okay. So now what we have is still 2 objectors that have a prior case pending against the same party, my client. And that case is still pending. You cannot split the claim. You cannot split the claim so now the caucus claim is all by itself. And let's talk about the caucus claim. There are sections, they cite the Township Code. They don't cite what section of the Township Code. With regard to the violations of any rules, while they say there's violations of rules, they don't allege any conduct that states that the rules and what conduct substantiates the violation of the rules. Additionally, they do not challenge the results of the caucus. And that is what's required. They don't name all the other candidates in their petition. For these reasons, this petition is deficient. You can't just simply have a statement, there was a violation of the rules, 1, 2, 4, 5, and 6, or whatever they put in their petition, without citing the actual conduct that purports to be the violation of the rule. For these reasons, this objection is deficient. It requires specificity. Fully state what the objection is, what conduct occurred that violated each rule. That does not occur in this objection. And for those reasons, it should be dismissed with prejudice.
Madam Chair, Board, I would love to engage counsel in the argument admit to the merits of the objection, which counsel has already started to do. But as a matter of fact, it's not working.
It's natural.
Got it.
Thank you.
Can you hear me now? Thank you.
Yes.
Yes, Madam Chair, I would love to engage in the merits and the arguments of the merits of this matter, but I don't think we're there yet unless this board grants or denies the motion to dismiss. We're here on,
My understanding is they don't want this to go forward because page 2
is missing, and according to their own motion, these were not fully or well planned. Well, first of all, the objector doesn't have to object to a candidate that they want. The fact that the objector decided not to object to some candidates and objects to some candidate, that's squarely in the province of the objector. And that's not a ground to dismiss the objector for one candidate or the other. The nomination certificate that produced all these candidates may have come from one caucus, but each candidate stands alone on the specific objection that comes with that objector. Page 3, and now we get into the objector's petition. Even though we don't have a page 2, page 3 of the objector's petition, I believe strongly, has enough in there that clearly and fully stated the nature of the objection. The part 8 and the paragraph below that specifically mention Napoleon Harris in his capacity as comedian. And he stated and alleges that has violated rules, even though it says above rules 1, 4, 5, and 8 of caucus day procedures, in accordance with the Illinois Township Code, which is the 60 ILCS. I believe that's enough, and then it says, while adopting rules that specifically targeted one possible candidate. I believe strongly that that alone serves notice upon the objector, of the candidate, of the nature, fully stated, of the objection. I would strongly argue that this board not dismiss this objector's petition and allow this matter to go on to hearing.
Mr. Solomon, let me ask you a couple of questions. Do you agree that the statute does not allow, once the time for filing objections is passed, does not allow amendments?
Absolutely, I agree.
Then where in this objection do we have before us the substance of the rules to be able to determine whether there was a violation or was not a violation of those rules without amending the objection petition?
The objector's petition clearly states the 60 ILCS as the statute that was violated. It's on there. And it's also alleged that rules were violated, the 60 ILCS. Now, we don't have the luxury of the second page. It would have been, maybe that would have provided more information, but I'm not here to argue where or what happened to the second page. I'm just here to say that the third page, standing alone and alleging, naming the candidate in his capacity as comedian, and stating the exact code, 60 ILCS, the Illinois Township Code.
Where in that township code, a 60 ILCS, where in this petition does it point us to what section to look at without us having to throw a fish hook into the water and hope we grab the right one?
I do understand that the specific ones were not stated in the objector's petition. However, it also states that election caucus day procedures, and I believe those are specific in the 60 ILCS, the Township Code. We can narrow down where caucus day rules are provided for in that, and we're not amending. I'm saying that we have enough to go about.
Where on the 2 pages of the objection that we have before us, does it state with any specificity what the chair of the caucus did not, how the chair of the caucus supposedly violated those rules. Where in this objection petition does it state that?
Two places that I can read, remember? The first one, adopted rules that specifically
Where are you reading from?
the only second page that we have now. There are 3 pages, I understand, second page is missing, so the last page, the very last page, where the objector signed at the bottom. And then the paragraph before, section 4, pre-caucus private part, the paragraph before that.
So it's that full paragraph before the number 4 and pre-caucus private part, you're referring to the paragraph just in front of that.
Yes, just prior to that, yes.
Does the board want any opinion from me on this?
Yes.
Okay, so my thoughts are, I mean, I've had a lot of experience with caucuses, especially this election cycle. I've had multiple caucus cases that I have, and I've also, multiple caucus cases that I've worked on, and also multiple caucuses that I've assisted. And I've also done a lot of election work. I don't think that this meets the requirements of section 10-8 at all. There are literally 195 pages of the Township Code, if you print it out. There, to say that just saying, well, you violated the Township Code, that's like saying you violated the election code. You know, there's zero specificity. And when we're talking about, you know, the paragraphs that are included, you know, the pre-caucus private party, there's nothing that prohibits them from throwing a pre-caucus private party to it. Do I personally think it's a great idea? Maybe not, but hey, there's nothing in the law that actually prohibits that. That's the first thing. Second thing is, in my opinion, as it relates to any sorts of violations of the rules, they would need to have alleged fraud and mischief and ill intent, ill conduct in order to get past the Lenahan standard, which basically says that we will not delve into the caucus procedures, and we will allow the sanctity of the caucus to stand and the will of the voters to stand. I do also note that there was a challenge that was filed in circuit court related to this caucus. That challenge was Supervisor Tiffany Henyard versus Napoleon Harris as it relates to the conduct of the caucus. That challenge was dismissed yesterday with prejudice because the judge, I read the decision, the judge basically said, well, you should have gone through the Electoral Board procedures. So obviously that's why they're going through the Electoral Board procedures here today. However, I don't think that they put enough in their complaint to withstand a motion to strike and dismiss. It would be my recommendation that the motion be granted.
I agree with this petition.
If I may, really
Go
quickly
ahead.
respond, Madam Chair. We have an unfortunate situation here. Yes, an action was filed in circuit court. However, this Electoral Board objection was also filed in time. So that covers, and that shows this board that we knew the objectors knew what they were doing and seeking remedy through both channels, the Electoral Board and the Circuit Court. Well, the Circuit Court ruled yesterday that, hey, you gotta go down to the Electoral Board first, and then maybe upon judicial review, you may return. And that's what the Signeri case that the Circuit Court, Judge Moreland cited. But here we have an objector's petition that's missing page 2. Again, I'm not here to belabor that. I don't know what happened. The objectors don't know what happened. But we have a situation where objectors' petitions were filed and it doesn't have page 2. And maybe, and I know that we would have been able to use the information we have on the now missing page 2. And maybe this board would have been fully informed as to the questions that the board is asking. But my argument is, given that page 3 serves enough notice, it stands alone
objector's petition, what I heard in the prior evidentiary hearing on this subject of what was filed, and looking at this, we should grant, my motion is that we grant the motion to dismiss on this objector's petition on the caucus issue.
Mr. Chair, Madam Chair, would you please allow the objector to address the board?
And pardon me, I don't know the names. One has withdrawn, and I don't think we ruled on that.
Mr. Smith, the one in the middle, he sent in the withdrawal. Mr. Price, the one on the far left of the table, he's still in the caucus case.
And we can allow him to speak with.
Well, he's now he's represented by counsel,
And
and
respectful.
he's asking your permission. He is asking the board's permission.
Yes.
So,
Thank you, Madam Chair.
And your motions?
Consideration of my motion, let us speak.
Thank you.
Thank you. Electoral Board, as we all know, page 2 is missing. I never even asked you all, could we try to get it back? Reading page 3, it clearly states that the rules that were broken were caucus day procedures. There's a list of caucus day procedures in the caucus guide that is issued. The caucus has a whole separate guide. Under caucus day procedures, you can easily see number 1, 4, 5, and 8. 8 being over this particular paragraph that I'm speaking on. And of course, 1, 4, and 5 was on the previous page. The violations are clear. The area in which the violations occurred clearly states caucus day procedures. So that was straight out of the caucus guide that everyone has. So I would like for this page to be omitted, of course, or this motion to strike and dismiss not to be granted, because there is enough information on the last page to address all the caucus day violations, with the exception of caucus participation violations, which was on page 2.
Let me
That's all.
just clarify one thing. Everyone does not have that document you referenced, because it was not in the packet of materials that have been submitted to the members of the board. So no, everyone does not have that.
And let me just say, I've never dealt with a caucus. I have no
I have.
idea. You have.
I literally helped edit the chapter of the vehicle, so.
You
I'm pretty
have.
well read on it.
You have, but you're not voting on this.
Correct, I'm not. I'm just making a recommendation.
And one of the people voting doesn't know what the issues are. You know, I don't know, and I was curious, you know, I know nothing about how caucuses run, so I don't know what the legal argument is, and it was not put forward in here. So that's the problem, and it's not up to the lawyer to explain to me how caucuses,
Correct.
you know, function, because that's part of, and it's not that it has to be every exact fact, but you give me nothing.
Yeah.
And if I may, one other thing is, you know, the caucus guide is a publication that's put out by the Illinois State Board of Elections, similar to the candidate's guide. So it's a guide, it's a how-to. It is not something that you base your objections upon. If the objectors wanted to hone in their objections, there's, you know, it's literally a very quick search of the Illinois Township Code. There is a specific article related to caucuses. They could have at least cited that article. They did not even cite that article. They just cited the entire Township Code, which is 195 pages. I don't think that sufficiently apprises anybody of what the nature of the objection is.
Well, I agree with you. I really don't know what the problem was.
Missing page 2.
Therefore, I renew my motion before this electoral board, that we grant the motion to strike and just motion to dismiss the objector's petition as it relates to the caucus issue.
Second, and was the objector done speaking, or did we cut him off?
No, I understood that even bringing the caucus issue before this panel, or electoral board, that I knew the board didn't actually have the authority to even rule on the violations at the caucus. I already knew that. I knew that this would be shot down because the board doesn't have the authority to rule on the violations of the caucus. That's why I filed it in the first place, so I could take it to court afterwards. But, I mean, of
And I
course,
think the judge in the Supervisor Henyard case said we do have authority. And I think I remember reading.
In fact, yes, so there's been plenty of cases in which caucus results have been challenged. I myself was a party, not a party to one, but I've represented multiple candidates as it relates to caucus challenges. There is a mechanism to challenge the caucus and to challenge the nominees from the caucus. I mean, obviously, we're here today challenging the nominees, in the other cases challenging, Napoleon Harris and Mr. Baker as it relates to their eligibility. So there are mechanisms to challenge the caucus. There are mechanisms to challenge the results of the caucus, but that's only if you can prove fraud and, other things. And really, the Lenahan case and the Hacker v. Haley, and Hacker v. Haley are really the seminal cases to look at when you're looking at not only how to conduct a caucus, but how to challenge the results of the caucus.
And I think I remember Attorney Solomon at another hearing saying, I wish I had written the objection. I have a feeling you wish that today. But with page 2 missing, we really have nothing in front of us to roll on.
So my suggestion would be we call the roll now and we move on to our final case. Chair, so just for the board's, or for everybody's edification, the board is now going to roll on the motion to strike and dismiss as it relates to trustee 01C. I'm sorry, supervisor 01C. Yes. Okay, so Chair Raymond?
Yes.
Member Swanson?
Yes.
Member Oswald?
Yes.
Motion carries. That matter is dismissed. So now we're going to move on to the trustee case.
Can Mr. Solomon file his appearance, please?
Yes, Mr. Solomon, can you please send us?
The board has granted me leave to do that, right?
Yes.
Yeah.
Yes.
Do we have to vote on
Do
that?
you want me to,
No.
do you want to do that now, or you want to email it to
Do
you?
you have any?
If I have a blank.
Ken is going to see if we have any blank ones. Yeah. And if we
And
do.
I'll serve it upon you so that it's.
Okay.
He doesn't have to read.
Let's go off the record one moment. So you don't have to type everything.
When I was representing the client, Chancellor, the judge told me, you would have won this case if you had been president of the union. So I understand your position.
Okay, so back on the record, we're going to call case number 25, TOEB, trustee 01C, and that is Keith Price and Michael Smith versus George Baker.
And as I informed you earlier, I was dropping that challenge.
Okay, so I was approached by Mr. Price right before the hearing started, and he had stated that he's going to withdraw the challenge to Mr. Baker.
Is
He wants to
Mr.
withdraw
Smith
the
also?
objector's petition.
Is Mr. Smith also?
Mr. Smith, can you step up to the mic? Are you also withdrawing the objection? against
Cynthia,
Mr.
tell me
Baker?
what to do. It looks fine on my end.
Yes.
Okay.
Tell me what to
Stephen
do.
Lezinski, Ross Seckler, Priscilla Centel on behalf of the candidate.
And do you have any objection to the withdrawal of the objection?
I have no objection.
Okay, so. the
Let-
board
let
has
me
the
know
objection
what to
the
do with
withdrawal
my
of the
mind.
objection.
I move that we accept the withdrawal and dismiss this case.
Go left.
Okay, Chair Raymond,
Yes.
Member Oswald,
Yes.
Member Swanson.
What's your saying, Mr. Lezinski? Malicious what?
Mischief.
Yeah, that's what's going on here today.
Is that better? Thank you, guys. It looks different on my end. I don't have my other phone. Thanks for being patient.
Okay, so there's no other matters before the board, but we do have to call for public comment.
A bit more?
So, you can't leave quite yet.
I'm against the wall. I'm against the wall now. This is the best I could do.
Okay, so the only other matter before the board is public comment. Are any of the members of the public wanting to give public comment? Okay, there seeing none, there being none, it would be my suggestion to do a motion to recess this hearing to January 31st at 11:30 a.m. for full hearing, hopefully, on the O2 case.
So moved.
All in favor?
It's not on my end. It's not. It's all the way zoomed out. Okay. I'm sorry, you guys. It's adjourned. My camera is all the way zoomed out. I don't know what I'm doing wrong. I'll have to practice some more. This is it. So.
Lazinski a copy of my appearance since he can't find me. He doesn't.
I am.
I
Okay.
have a copy for the board.
This is the best we got, y'all. Sorry.
He doesn't.
Thumbs up for me being on my feet the whole 3 hours. The whole 3 hours I kept on trying to adjust so y'all could get a better thing. Okay? Thumbs up the video, consider contributing to the channel, and consider subscribing. And the 31st, this is going to be interesting. Hopefully, Critical Smoker and Reality Check are back. You know, they are professionals at this. I'm just filling in because nobody, they weren't coming. I'm their understudy. All right, let's get up out of here, y'all. Thank you so much for the support. Thank you, Wyoming. Y'all, I've been on my feet this whole time. So yes, Tiffany did come, and so Tiffany came. They dismissed the trustee case. Oh my gosh, this residency case with Senator Napoleon Harris is going to be crazy. New trustee Stephanie Wiedemann came today as well. What else? We'll just recap it later. I have to get me some lunch. And thanks for being patient with allowing me to get this content, you guys. It was very difficult. We decided, remember we were live. We decided 20 minutes in we were going to go live. All right, let me grab my book bag. And sorry, y'all, I don't know how to turn this tripod thing. That's why it kept shaking. I don't know. I got to learn how. I'm going to play with this at home when I get spare time. Let's walk on out. Let's see what's new and happening. Okay. Thank you for catching that for me. Thank you. Bye, Emma. See y'all later. Have a good one. Yeah, so it looks like my camera zoomed out on my end. So I'm going to have to ask Critical how to do this because it looks like my camera is zoomed out. So I'm about to go. Supervisor Henry is over there. Okay. And I'm going. Ooh, it's cold, you guys. Okay, you guys. I'm going to end it here. Like the video. Consider subscribing. Everything looks good to me right now. I don't know if I'm going to Panera, Chipotle, Harold's Chicken. I'm just hungry. And I didn't have much. I love you guys. See you next time. Be safe. And I'll see you for the review. Shout out to, make sure you subscribe to Reality Check TV and Critical Smoker because they're usually doing the, so if I have any mods, can you put them in the chat? And thanks for helping me out and guiding me while we were covering this. Love you guys. Bye.